see an appearance by defense counsel, nor have they responded. This was, I think, set for 9:30. It's now what, 10:02. We waited a sufficient time. No one's here. Are you aware of any response?
No, Your Honor, and that's our problem, is that we've continued to try to reach out to them. The ALJ has continued to try to reach out to them. The Workers' Disability Compensation Agency is trying to reach out to them, to no avail.
All right, well, granted, the only, I'm going to grant this with prejudice unless they appear and tell me they were somehow disabled and not able to attend. It looks like from the filings that I've seen, you've done whatever you can do it. They have let it go.
That is correct, Your Honor, and they have not had any insurance from May 21st, 2023 until the present. They make approximately $9 million in revenue every year. They have filed with Laura, and it's unclear. It was brought to our attention because 2 people have filed disability workers' compensation claims because of injury, and they don't have any insurance, haven't participated in any of the tribunals or administrative hearings.
All right, well, I don't see an order, but if you present an order, I'll be happy to sign that.
Thank you, Your Honor. I apologize. I just came in on this case.
No problem. So if you get that to me, and we'll do that with prejudice unless there is, they certainly will have their time to object to it, but I don't see anything here that should keep this open. So thank you for bringing it to my attention. So it's not on the no progress list.
Thank you, Your Honor.
All right, thank you. Have a good day. That's all for the record.
Here's the one from yesterday. And the next one's at 10. We got this one on the plane before. Good morning, sir. What case are you here with?
Oh, I'm just here to say hello. I don't get here much anymore.
How are you? Haven't seen you in a while.
Yeah, I'm busy other stuff. I'm here for the house auction right now.
Oh,
We want to wait another 10 minutes, probably. Won't wait to see if he's gonna show. Scheduled for 10.
you're here in a case?
No, I'm just for the house auction.
Oh, yeah, I just thought maybe you were also stopping in on a case too.
No, I'm not. Mainly in Clinton right now.
Oh,
They
really?
give me so much stuff out there. I don't have anything else.
Oh,
It's amazing. I never knew.
yeah.
All right, I'll see you.
Nice seeing you.
I have not.
All right, so is anyone here on the Cassidy case?
Good morning, Your Honor. J.R. Paul.
All right, let me just call the case. I wasn't sure. So you're here on Zoom. We also have, so we have both counsels, so we're ready to proceed. This is docket 26-1914 CZ. Kevin William Cassidy versus Cancer and Hematology Centers of Western Michigan PC, doing business as the Urology Institute, formerly identified as Lansing Institute of Urology, and John Jane Joe's 1 to 20.
Your Honor.
Nancy's not here.
Oh, where'd Nancy go? Thanks. I just always assume she's there, she was there a minute ago. I have to call the case again, sorry, no court reporter.
For defense, right? Defendant? Oh, plaintiff, other side, then, sorry. You were right. I thought you were here for defendant, sorry.
All right, so.
Did you go?
Yeah,
help me?
I always assume you're there, I didn't look up, sorry.
I did go get this one and I go.
That's okay.
Redo.
Yeah, we thought we were still waiting, that's okay. All right, we're gonna have a redo. This is docket 261914 CZ, Kevin William Cassidy versus Cancer and Hematology Centers of Western Michigan PC, doing business as the Urology Institute, formerly identified as Lansing Institute of Urology, and John/Jane Doe's 1 to 20. Counsel, your appearances for the record.
Your Honor, Kevin Cassidy and propria persona.
Good morning, Your Honor. J.R. Paul, P-O-L-L, appearing on behalf of defendant, Cancer and Hematology Centers of Western Michigan.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, thank you. And on behalf of defendant, you may proceed, counsel. And before you do that, you've received his motion?
Yes.
All right, thank you. You may proceed.
Thank you, Your Honor. And before I make a few comments about the motion, I will say that I received a filing for Mr. Cassidy, I think it was yesterday, indicating that he was unable to appear in person and requesting a Zoom appearance. When I received that, I had my assistant contact the court, and I was advised that the hearing would be by Zoom. That's why I'm appearing by Zoom. I just wanted to say that for the record.
It's pretty common since COVID for attorneys, especially you're in Grand Rapids, right, sir?
Yeah, that's correct, Your Honor.
Yeah, so you don't need to drive the hour. I mean, once in a while, I prefer it in person, but this is just fine. The only issue is make sure that, and you seem like you talk at a really good pace. The only issue we have with Zoom is people talk too quickly. And sometimes there's a blip, we might stop you, but other than that, this is perfectly fine, but thank you for the explanation.
Thank you, Your Honor. So this is defendant's motion for summary disposition in lieu of answer, principally under subrule C8. I've briefed the issues extensively. I'd be happy to answer any questions the court has about the motion. I've outlined the detailed, extensive history plaintiff has of filing pro se actions in the federal courts of the state. There appear to be two other cases pending in Ingham County that were filed on the same day. It looks like those have been assigned to other judges, and a few others that were filed in Saginaw and Midland County as well. It appears, I looked at those cases this morning online. It appears they all have pending motions for summary disposition. I won't comment further on that, but I wanted to point that out for the record. To the
I
extent
appreciate that. I did notice that, so they're all pending now. They weren't And I know you're asserting that they're vexatious pleadings, but they're all filed at the same time?
I think the two that were filed in Ingham County were filed on the same day. I believe the one in Midland and the one in Saginaw were filed a month or two later.
All right, thank you.
But Your Honor, to the extent any allegation, any coherent allegation can be gleaned from the complaint that's been filed, it appears that Mr. Cassidy submitted a request for medical records, his medical records from the Lansing Institute of Urology in January of 2025, and isn't satisfied with the response he's received. There's really no further detail in the complaint about the response or what specifically his complaint is about the response. But it appears that he's allegedly received care and treatment at the Lansing Institute of Urology at some point prior to January of 2025 and believes he a possible malpractice case and he needs more records to investigate that potential malpractice case. As we've outlined in our motion, there's no independent cognizable cause of action in
No, wait,
Michigan.
no, independent, wait,
Nate, he said there's no independent cognizable cause of action.
thank you.
Sorry, Your Honor, I need to slow down. I apologize.
It's, your pace is okay. Sometimes the Zoom is a little bumpy, so I'm understanding, it just doesn't always. We're good, thank you.
Understood, Your Honor. So the essence of our argument is the complaint fails to state a claim upon which relief can be granted under Michigan law. There's no recognized independent cause of action relating to incomplete or insufficient production of medical records. The rule is the same in the federal in the federal world with HIPAA. HIPAA doesn't create a private cause of action. That is clear in the case law.
HIPAA doesn't, wait,
So one
wait,
moment, HIPAA does not create a private cause of action.
all right.
Thank you, Your Honor. So the essence of our argument is that the complaint fails to state a cause of action upon which relief can be granted. What this seems to be is an attempt to gain the right to conduct discovery based on nothing more than pure speculation. And I think that would clearly be a fishing expedition, and there's really no basis for that in the case law. So unless the court has further questions, I think I've adequately briefed the issues. I'd be happy to answer any questions, but I'll reserve the remainder of my comments for any rebuttal.
All right, and he can answer this, but as far as you know, and I understand the whole fishing expedition, the additional information he wants, but he's entitled to his medical records, which have already been provided, correct? Nothing's been withheld that he's entitled to, is that correct?
Not that I'm aware of, Your Honor. In fact, I think what the affidavit I attached to the motion says is we have no record that Mr. Cassidy has been a patient of Cancer and Hematology Centers of Western Michigan. So I'm not sure there's even anything to provide.
Okay. All right, thank you. Sir, what would you like me to know? Please come to the podium. And first, if you could address, were you a patient of defendants?
I was a patient of Lansing Institute of Urology. That is at the same address as the Cancer and Hematology Centers of Western Michigan.
Okay, and have you received your medical records from whatever it is you had done?
I have not, Your Honor.
Okay, and did you identify the surgeon or the physicians you saw the dates of service?
First and foremost, this isn't a malpractice case. It's records production from my own urology records. I have tried numerous times to obtain them outside of the courts, and they have not produced them. They're saying the name change has
Let me
No,
stop you there. I don't
Yes.
care what they say. This
Okay.
attorney knows. I think he's acknowledged. If there is documentation that belongs to you, they're willing to give it to you. That's the law, and they can change their name once or 17 times as long as you were a patient there. Doctors operate under very strict rules about how long they have to maintain your records. So we do not file lawsuits for fishing expeditions to see if there is malpractice. And the issue here is you need a doctor. So you have it looks like from what you've told me, you were a patient at Lansing Institute of Urology, is that correct?
correct, Your Honor.
Who was your doctor?
Dr. Zuckerman.
Okay. And what dates are you looking for?
I have a first appointment roughly 10/12 of 2017. And I believe last visit I had there would have been around 2019 or 2020 maybe.
Okay, so you're looking at any of your records that you want a copy of between October 2017 to 2020. Is that all you're looking for?
Yes, Your Honor, for the most part. Yes, I just want my records.
Stop right there. Sir, can you just get him his records if they exist, and if they don't exist, give him a certified letter affidavit saying they don't exist? I mean, I'm correct, right? And I think you know this, sir. Doctors have to maintain records and let people know where they are for a certain period of time. And so if this was 2017 to 2020, Lansing Institute of Urology would have them somewhere. Am I right on that?
Your answer, Your Honor, the motion and brief I filed included an affidavit signed by, I believe, the CEO of Cancer and Hematology Centers of Western Michigan. Cancer and Hematology Centers of Western Michigan had no ownership interest or contractual relationship with Lansing Institute of Urology in January of 2025 when this request was allegedly submitted. Therefore, it really had no role in any response to that request. There's what I've been told, and what's outlined in the affidavit is there's no record in the system of Cancer and Hematology Centers of Western Michigan that Mr. Cassidy was ever a patient. That's what
Okay.
my understanding is.
Well, and I have, that is, if I've got the right exhibit 6, and I believe that's where I saw the affidavit of Stuart Genshaw, Genschhaw, CEO. And it says that he's the chief executive officer. He has personal knowledge, and CHC has no ownership interest in Lansing Institute of Urology prior to 2026. It was owned and operated by a different entity. And is there one that specifically addresses, and there's a lot of case law and other things attached, is there one that specifically addresses the Institute of Urology? Because I think this is more of a licensing issue than a lawsuit issue.
Well, Your Honor, I think that's sort of my point, is that this isn't the type of issue that the legislature provided for being resolved in the circuit court. And I think if there's an issue, I think that it's something that is resolved through the Michigan Department of Licensing or
Correct.
Bureau of Health Professions, and not a circuit court action is the
Correct.
essence of my argument.
Yeah, and I agree with that. I just like to circumvent other agencies getting things that could be, you're gonna end up with different problems, that nobody wants that either. The doctors don't want to go through that. If he's just asking for his records, he's entitled to that. This document, this affidavit doesn't say that it talks about ownership. It doesn't say that they've searched their records or that they had any control, that they did or did not have any control over the documents during the time period he's requested. And maybe his request was not as clear as what we're doing today. So what I'm just asking, sir, I have no reason to keep this open. You can't go on a fishing expedition, and I'm the wrong forum. Your forum to get your records is with licensing, the Department of Licensing, because doctors, to be licensed, have to maintain certain standards, and you do own your file, and you are entitled to those, and if they do not give that to you, then there can be sanctions there. I deal in the lawsuit if it warrants it, if there's malpractice or other kinds of behavior, but it is not right for me at this point to have this case. Now, you have a very good attorney on the other side, and I am certain, counsel, that you will request these documents and send them to them if they exist, and maybe we could have a letter saying they do or don't exist, and then circumvent next steps, which is going to cost everybody time and money. Can we do that?
Your Honor, I am happy to check with my client to see if what exists in terms of what they have access to for Mr. Cassidy as a patient. I'm happy to follow up again with my client and ask them about that. Yes.
So am I understanding from this caption, and maybe I don't know that you created the caption, probably plaintiff did your client purchase the practice of Lansing Institute of Urology or not?
Your Honor, you're right that Mr. Cassidy created the caption, and I'm not a corporate transactional attorney, but my understanding is there was some type of asset purchase that was completed in February of 2026, and I'm not really privy to the particulars of that transaction.
Okay, well, as much as I appreciate your affidavit, I think that and it does say in January of 2025, when plaintiff allegedly submitted a request for medical records and notice of court of claims, CHC had no ownership interest. So maybe they don't have any connection, but if they do, please provide them documents or a name of a contact. If you can't, then he certainly can go to licensing. So you can go to licensing and ask for who the owner is or was, and then make a complaint that you have made requests and you have not received those documents. Now, Dr. Zuckerman, in our community, I've heard his name, I've never gone to him. Is he still in practice?
I cannot tell you, Your Honor.
Okay, licensing can. So, sir, you're just in the wrong forum. If you want your paperwork, you need to go to Dr. Zuckerman, make that request. If he's no longer available, you can't find him, you go to licensing, and they will help you out one way or another. It's just, this is the wrong forum for me. So, nice try. I know you're not a lawyer, but as to any of the other lawsuits you have filed, if this is the same situation, you might, before you get hit with costs or anything, want to withdraw those and go through the proper channel, which would be the administrative route through licensing. Okay, and that's through the Attorney General's office. So you can Google that, and you know, you're gonna get some answers. Nobody likes to have their license checked by them. It's a painful process. You're entitled to your records. I don't know any doctor that withholds papers unless they lost it, or they have, and that just doesn't generally happen. There's a paper trail for doctors. I mean, I'm of an age where many of my doctors have retired, and I've had to go physically and pay the $50 or whatever it is to get my copies, to get to another doctor or what have you. So I get that, it's frustrating. But circuit court, there's no remedy that I can provide, because you're not claiming malpractice, you're claiming discovery issues, and we can't get to discovery unless we have an issue. Okay?
Yes,
so if and when you find that there's a problem, come back to courts, but please review all of those claims that you have filed, and if you're requesting the same thing, I have not seen them, withdraw them, go to licensing, and then see if you have a claim or not, and maybe consult with an attorney who does this. If you can't afford an attorney, usually these, and I can't speak for all attorneys, but there are many attorneys who take a percentage. So you don't even have to put anything up, you know, if there's a claim. But I suspect if you did talk to attorneys, they've told you, don't do this. I don't know what you did or not, but this just isn't the right forum. Do you have any questions, sir?
Can the defendant identify the records custodian?
He says he doesn't know, they don't. That's why I'm telling you to go to licensing. Sir, you don't know the custodian of, Lansing Institute of Urology, correct?
Your Honor, sitting here right now, I do not. What I can say, and for Mr. Cassidy's benefit as well, I can follow up with my client to determine what the appropriate location would be for a request for records if he was seen at Lansing Institute of Urology in 2017 through 2019 or 2020. I'm happy to do that.
Yeah, so he's willing to work with you. You have his address, sir. Mr. Cassidy, your address is still on Stark Road?
Yes, Your
All
Honor.
right, so sir, if you could, and he's got his email there, that would be appreciated. I am dismissing this case.
Thank you, Your Honor.
It's on the order. There is no, whether it's, C8 or C10, it both apply, and this is worthy of being dismissed, but we do have a guy who needs some help. And so if you would appreciate, if you would give him some information, that would be appreciated. And again, licensing is where you want these cases to go. Review your other cases, because some judge may really smack you with costs, and they have a right to ask for them under our court rules. So be very careful when you file these pleadings, sir.
Yes, Your Honor.
Your Honor, may I submit an order under the 7-day rule?
Please do, sir.
Thank you, Your Honor.
Thank you. Appreciate your help, sir. Thank you. Good luck to you, sir.
Thank you.
Set for 10:30. But I see two gentlemen here, and they're sitting on opposite sides right now. I saw them go out to chat, so I'm guessing they're both here on Cordier versus Lowe's.
True. Yes.
Look at that. Come on down, gentlemen.
All right.
All right. Ready? Okay. This is docket 25201NO. Noel Cotier. I'm not sure if I said that correct. As next friend of Ruth. Is it Cotier?
Interior.
Cotier?
Yes.
Okay, thank you for that correction. Versus Lowe's Home Centers LLC, and Jane Doe. Counsel, your appearance for the record.
Ridley Nimmo appearing on behalf of defendant Lowe's Home Centers LLC.
Good morning, Your Honor. Tyler Joseph for Noel and Ruth Cotier.
Thank you. This is defendant's motion for summary disposition. So you may have a seat, sir, if you could come to the podium. Thank you.
Thank you, Your Honor. As Your Honor indicated, this is the time, date, and place for the hearing on defendant Lowe's motion for summary disposition brought pursuant to MCR 2.116C10. And as Your Honor is likely aware, this incident arises out of mom and dad. Mr.
I'm sorry.
Mom and dad.
Mom and dad
Okay. That's right.
of young 4-year-old Ruth are looking for a refrigerator. So they go to the Lowe's in Lansing, and they're shopping for that refrigerator with their young daughter, Ruth. Initially, Ruth is in a shopping cart. Ms. Cotier testified that her normal protocol, given the young age of her young daughter, 4 years old, that her normal protocol is Ruth's in the shopping cart. Apparently, at some point where mom and dad are shopping for appliances, young Ruth wants to get out of the shopping cart, so mom gets her out of the shopping cart. This is all uncontested testimony. When Ruth is removed from the shopping cart by mom, she's kind of just wandering around the appliance department, not really being closely supervised by mom and dad. And so during the course of their shopping for a refrigerator, mom and dad are asking the employee, who we know is Nancy Knight, everybody agrees is a nice lady. They refer to her as an elderly lady, grandma-ish kind of lady. In any event, so Nancy Knight, at plaintiff's request, is scanning things for them so they can find out additional information regarding the various refrigerators they're looking at. And by the way, the scanning device is referred to commonly as like a zebra phone. But just so Your Honor has an awareness of what it is, and everybody's testimony is this too, this looks like a cell phone, looks like an iPhone. It just happens to have some scanning capabilities to it, but it's essentially, looks like an iPhone. They call it a zebra phone. It serves as a scanner.
I'm sure that I've seen them a lot.
Probably.
It's probably at Myers and everywhere where they scan the barcode, right?
Yeah, you can scan the barcode, and I think there's probably different devices at different stores. This one happens to look like an iPhone.
Yes.
Some of them, I guess, I've seen in other stores, they look more of like a contraption of some sort scanner that has, like.
With the handle or whatever, but this
Yeah.
is more the iPhone
It
flex. Okay.
It. And so at Plaintiff's request, they say, hey, can you get us the additional information about this particular refrigerator? Nancy Knight, in her usual fashion, she scans the barcode that happens to be located above the refrigerator. She brings her scanner down to her side, just like anybody normally would. And the undisputed testimony is she does this in a normal fashion. It's a routine. She just goes to scan, brings it down. Both mom and dad who are there and witness it both say, hey, it was a normal scanning motion. And it just so happened when she brought it down to her side, unbeknownst to Nancy, young Ruth happened to be standing off to her right behind her in a blind spot, unbeknownst to her. And she bumps her in the head or she believes she does. She feels something bump, and she's assuming she bumps young Ruth in the head with the scanning device. Testimony is at that point, young Ruth is standing there, looks at mom, who's off to the left-hand side of Nancy, and goes to her mom on her own, by the way. And there's some reference in the response to the motion that she's on the floor seizing. That's not the testimony. What it is, Ruth, after the incident, looks at mom. This is mom's testimony. Goes to mom. Mom hugs her. She, for a period of 5 seconds or less, believes that Ruth experienced what she describes as seizure-like symptoms. Mom's the only one that observes these seizure-like symptoms, but it supposedly happens for a period of 5 seconds or less while Ruth is in her arms. So in any event, mom is like, call 911, call 911. So 911 is called by an employee immediately, and 911 gets there, or EMS gets there, and when they get there, they obviously look at Ruth. Mom says, hey, I was holding her for a period of 5 seconds or less. I believe there was some seizure-like symptoms. And when they look at her, they see nothing. It's a normal neurological examination. The Glasgow score is as high as you can get. It's a 15. Normal pupils, normal speech, normal strength, no facial droop, no swelling, no crepatitis, no deformity. That's what they all note in their EMS report. But they do take Ruth, as you would imagine, off to get evaluated. And when she went and get evaluated by the hospital, she had an MRI and an EMG, both of which are normal. It's all normal testing. And there's also, and as you know from reading the materials, young Ruth had experienced one or more occasions of seizure-like activity or things along that nature where she was supposedly being observed for these conditions. Mom even made reference of that immediately after the incident, which was heard by others. And it's even noted in the hospital records. And I think even noticed I think it's even referenced in the EMS records. In any event, and there's been no subsequent alleged seizure activity or anything like that by young Ruth since the date of this incident. So in any event, the claims that are being asserted here are negligence and gross negligence. Count one. Second claim is negligent hiring of apparently Ms. Knight. And the third claim is negligent infliction of emotional distress. This motion points out the problems and dispositive problems we contend as it relates to each one of those claims. So as it relates to no negligence, we point to, and I guess I really didn't realize this before filing this motion, but there is law that involves minors being on the premises of shopkeepers and what the duties are of shopkeepers as it relates to minors on their premises when they're with their parents. And it come to kind of what you would,
And
they come to what I would consider and what's kind of considered a common sense law, legal reasoning. And they say, hey, as a matter of public policy, it's mom and dad that have the obligation to supervise and keep an eye on their children, not shopkeepers. And so the first thing that we raise in response to this motion is, hey, that's mom and dad's duty to make sure child is being appropriately supervised and is not in a place where they shouldn't be, and those kinds of things. That's not shopkeeper's duty. So we believe that the claim fails as it relates to no duty. Secondly, we point out that the uncontested testimony is Ms. Knight is doing her scanning in a normal fashion. They're not saying that she's doing something that's out of the normal or even doing something over the top as it relates to her normal scanning. They all concede, everybody concedes. Yes, she did this in a normal fashion. And everybody also agrees that Ruth is in a location where she would not have been seen by Nancy at the time of the incident. So everybody's on board with this. And incidentally, both mom and dad testified, that Nancy, she was kind, she was helpful, she was behaving in a normal manner, and they really don't have any complaints about how she did her scanning activity. And in fact, there's testimony that mom, after the incident, says, don't worry, you're not at fault. You're not at fault, right to Nancy. So in any event, our second argument as it relates to the negligence, gross negligence, is there's really no evidence based upon the undisputed testimony that Nancy was negligent. She was doing her job in a normal fashion, and everybody agrees to that. So that's the second problem. And I would point out this, not only is there no evidence of negligence, it's a no-brainer that there's no evidence of gross negligence. I mean, the gross negligence is willful and wanton conduct that is totally disregarding what you should be doing. Not only is it not negligent, it's clearly not grossly negligent. And then we also talk about proximate cause of damages and all that kind of stuff. I went into the testimony. What we have here is mom's testimony, and only mom's testimony, about this alleged seizure-like activity once she's hugging Ruth. When Ruth comes to her after the incident, she's hugging her. She says for a 5-second period or less, she believes that there was this activity going on. Whether it was, I don't know. That's what mom seemed to perceive for that short period of time. All objective testing was normal. All objective testing has continued to be normal in terms of not relating anything to this particular incident. So those are the fatal deficiencies as it relates to the negligence claim. And I'd also point out that the law is well established, and I know you know this, Your Honor, that just because there's an incident that occurs on a premises, does not mean that somebody was negligent or there was negligence. You have to actually, as a plaintiff, prove it. You can't just say, hey, there's this incident, question of fact. That doesn't work. All right, as it relates to count 2, negligent hiring and retention and training, there is, well, first of all, in order to establish such a claim, plaintiff has to establish that Lowe's was on notice of something going on with Nancy before this incident that would have alerted them that, hey, an incident like this may well occur. There's zero evidence of that. First of all, there's no evidence that Nancy's had any issues or problems. And in fact, the undisputed evidence is she hasn't had any issues, problem related to anything, let alone haphazard scanning things. So that's fatal to the claim. Second, 2, I mean, Lowe's, it would be impossible then for them to be on notice of something or some issue or problem if there's nothing to be on notice of. So we know Lowe's is not on notice of anything. So that's the fatal deficiency as it relates to their negligent hiring and retaining. And, so, and by the way, it seems like plaintiff's counsel kind of is acknowledging that in their response. And so the response focuses on, well, we think maybe she wasn't appropriately trained. Well, really, what evidence is there of that? Do we have an expert that's out there that says, hey, in the retail world, you need to be training your employees how to scan, and this is how you're supposed to be training them on how to scan. And Lowe's, your training is deficient. There's nothing like that. Nothing even approaches that. And I don't even know how you could improperly train somebody to scan, to be honest with you. I mean, that just doesn't smack me as something that makes any sense. Final count. Negligent infliction of emotional distress. This is asserted by mom. It is her bystander claim. First of all, I point out that mom admits that she didn't actually see the contact between the phone and supposedly the girl's head. She did testify that she observed whatever she did for that 5-second or period of less where she perceived some kind of maybe seizure activity going on. And incidentally, keep in mind, mom is cognizant of, hey, we've had prior issues with Ruth and seizures. And so that might be factoring into her, thought process during that 5-second period of time or less. But in any event, so we point out no actual witnessing of the event by mom. And then we also point out that in order to maintain such a claim, there's 2 additional elements that are key. First of all, the conduct has to be significantly outrageous enough to likely result in some kind of emotional distress by the bystander. Well, here we don't have any remotely outrageous conduct whatsoever. And then you also have to have a physical manifestation, not just a, hey, I'm mentally affected by this, but the law is, and that's the Henry v. Dow case, you actually have to have a physical manifestation that accompanies your distress. They don't have either. And by the way, I deposed Noel mom, and she says, I haven't received any counseling, any treatment, nothing going on in terms of medical treatment, medical issues, or even counseling relating to this incident, which is not surprising, but she acknowledges that during the course of her deposition. And so the cases that they cite in the response, the cases that they're citing that the courts decided, hey, there's maybe, or there is a question of fact, they're talking about examples where a parent is watching their kid get run over by a truck. A parent is watching their kid get shot and killed. A parent having a birth, stillbirth, and seeing their dead child born. That's not what we have here. And the physical manifestation cases that they're citing too is the parent unable to socially function whatsoever in society, them undergoing tremors and shakes and being in a comatose type state. We don't have anything remotely approaching that. What we have is mom saying, yeah, after this incident, I haven't had any medical treatment whatsoever, no counseling whatsoever. And I said, well, your lawyer suggests that you may have been seen by a Dr. Shiner and maybe a Dr. Seawick. She confirms, yeah, that's not my treaters. Yeah, my lawyer sent them to them. I have no idea what they have to say about anything. And then lo and behold, on the eve of this motion, I, for the first time, see a report from Dr. Shiner that I've been asking for months and months and months and months. But it pops up in response to this where he says, hey, I think she's got PTSD or something like that. And then for the physical manifestation, he doesn't even really come up with much. I mean, doesn't come up with anything close to what the case law would suggest is physical manifestation. The best he can do is she has disturbed sleep. She can't sleep. Disturbed sleep. She can't sleep as good. And she's gained weight. Well, I don't know that was well, first of all, how in the world you can relate that to this incident is beyond me. Second of all, I point out that Mr. Shiner, Dr. Shiner, is he's not a medical doctor, he's a psychiatrist is what he is. I mean, I guess maybe he's a medical doctor as a psychiatrist, but he's not a treating doctor for physical symptoms related to anything like this. Certainly not a neurologist or anything like that. So for all these reasons, we believe that each of the 3 counts fail. And I'm happy to answer any questions that you may have.
Don't have any at this time, maybe after I hear plaintiff's counsel.
Thank you.
Mr. Joseph, you may proceed.
Thank you, Your Honor.
There are 2 fatal flaws with defendant's motion. The first is that they completely misconstrue the idea of duty. The second is everything that they're arguing are questions of fact that go to weight, not necessarily dispositive on a motion. I think it's undisputed that Nancy Knight was an employee of Lowe's. She was working that day. What she was doing was within the course and scope of her employment, and she struck Ruth in the head. I don't know in what world striking a child, I don't know in what world or in what basis under Michigan law there is that there's no duty not to strike a child in the head. We're not saying it was intentional, and the court knows it doesn't have to be intentional. That is similar to, and I'm sure this court sees a lot of auto accidents. That is similar to an auto accident where a defendant rear ends somebody and their testimony is, well, I was paying attention and I wasn't speeding. I wasn't doing anything wrong. It was an accident. Court is never going to dismiss that on a motion for summary judgment, summary disposition. Here, Miss Knight testified that Ruth was on her hip the entire time. She was a friendly little girl. She was walking around the store and she was asked to scan a barcode on a refrigerator. She testified she took this big clunky rubber zebra phone. She had to reach up on her tiptoes to scan it. And as she's bringing it down, Ruth is right where these were right out of Miss Knight's mouth. She was on her right hip the whole time. Ruth was right there where she had been. She brings it down and she strikes Ruth in the head. You know, these arguments that, oh, it wasn't that bad, or, you know, it wasn't that big of a deal. That's a really convenient argument for a defendant to make when they've produced video of Ruth and her mother and father coming into the store, video footage of Ruth getting wheeled out on a stretcher, but no video of what happened. Very convenient for defendants.
Is there video of what happened?
There is video of the parents and Ruth in the appliance department the entire time shopping. The incident happens to occur at the back of the department behind appliances, behind refrigerators. So it's out of the view of the appliance department.
Okay, so my question is a little larger. I appreciate that answer though, because that answers another question I had, but you've provided the video that you have in regard to this incident, or is there more that hasn't been provided?
Well, first of all, all video that exists related to this incident have ever existed has been provided. It shows the plaintiffs before they even enter the store, entering the store with Ruth, with her in the shopping
But
cart.
the incident occurs where there's a blind spot.
Yeah, but it shows the appliance department, shows them shopping in the appliance department,
Okay.
doesn't, but there is no video of the actual incident, never was any video of the actual incident, because that's.
Just want to be clear on that.
Yeah.
So, okay, so would you agree with that? It's a blind spot? I mean, you've been provided video, there isn't.
I mean, no, I don't. I've had a lot of cases with big box stores. I took the deposition of, I believe it was the manager at the store, and his excuse was, well, people don't really steal refrigerators. I know why big box stores have cameras. It's not just because they think people are going to steal things. It's because they need to monitor, they need to see their own employees. And when things like this happen, it's on video. So that is defendant's stance, that they don't have video. I am just pointing out at this stage, it's very convenient that they have video of them coming into the store and Ruth getting wheeled out on a stretcher going out.
Okay, but you have no evidence that there is or is not a blind spot. I mean, I just want to be clear that you're not asserting that somehow they're playing hide the ball and they've given you everything they have and they're saying, we don't have a camera there. That's for whatever reason their decision, but you're not saying they've lied about something they haven't turned over.
No, I concede that I have asked for everything. They claim they've given me everything.
And by the way, he's even taken the testimony of the people that know where cameras are or are not, and they've unequivocally confirmed there's no camera.
Okay, just want to make sure we're clear that there's nothing being hidden. Okay, so I've got that. Thank you.
And back to this idea of duty, Your Honor. Not only is there a duty to pay attention to what we do in our daily lives, to make sure we're aware of people are, when it involves children, there is a heightened duty. And it's right in our jury instructions. I had this jury instruction read a couple months ago in a case when a little girl was struck by a car. And Michigan Civil Jury Instruction 10.07, conduct required for safety of a child. The law recognizes that children act upon childish instincts and impulses. Now, there's no allegation here that Ruth was doing anything. She wasn't roughhousing. She wasn't running around in circles. I have a 4-year-old. I know how it goes. Sometimes they do those things. No testimony here that she was doing any of that. She's merely being friendly, walking around with Miss Knight, something an adult might do. And Miss Knight concedes she was on my right hip the whole time. Back to the instruction. If you find that the defendant knew or should have known that a child or children were likely to be in the vicinity, here, Miss Knight claims she didn't know. She should have known. It's her own testimony that Ruth was on that right hip the whole time. Then the defendant is required to exercise greater vigilance. And this is a circumstance to be considered by you in determining whether reasonable care was used by the defendant. That's right in our jury instructions. And if this case goes to trial, we're going to be asking that this jury instruction is read. There is not only a duty, there is a heightened duty. So this whole argument about duty is a huge red herring. This is a very simple case. We're not alleging that Lowe's had a duty to supervise Ruth. This isn't a case where Ruth was wandering around the store and she fell like in an event or something. She was there to be seen. She was there the whole time, and Miss Knight negligently struck her in the head. Now, all of this talk about what happened, how it happened, what the injuries are, these are all questions of facts for the jury. This is not something that the court can determine on a motion for summary disposition. The court, as the court knows, takes the facts in the light most favorable to the plaintiff on this motion. And the plaintiff's facts are that Ruth was struck by this big, clunky zebra phone. She immediately went into her mother's arms. Noelle testified that Ruth's head went back, her eyes rolled into the back of her head, and she began to seize. Defendant can dispute this all they want. They can say it's not that big of a deal, it's not that bad. They're wrong, but more importantly, that's for the jury to decide, not the court. And that segues into the bystander claim. And we've cited case law that this idea that she didn't see the strike, she saw the immediate aftermath. And the case law is unequivocal that seeing the immediate aftermath within seconds is enough to establish a bystander claim. And again, these arguments that it's not that bad, these are all questions of fact for the jury. I don't know what could be more traumatic as a parent to hold a child in your arms who has just been struck in the head and is having seizure-like symptoms. I can't think of anything. I'm sure there are. I've had some very terrible cases, but as a parent, there's no question in my mind and under the law that this meets the threshold for a bystander claim.
Can you answer the issue that counsel raised, and he's also briefed it in regard to the duty owed to the child when it is the pursuant to the Wheeler versus Central Michigan Inns Inc. case 292 Mishap 300. It's a 2011 case, and there's some other cases that were cited, but essentially the thought behind that is that parents are responsible for their children. There's no duty owed by Lowe's to supervise the child, and the child, according to them, was in a cart and safe, and then gets out of it and then is around the store. Isn't it the parents' duty or not? What is your take on that interpretation of that case and ruling?
It is not, and that's a complete red herring. In those cases, those children are injured by something on the premises, not by a direct act of an employee.
That act though was accidental. She didn't aim to hit the child, right? I mean, and you're asserting gross negligence. How does gross negligence fit into this when she scans it, brings the hand down, and oops, there's the child?
Well, there's absolutely unequivocally negligence. Whether there's gross negligence, it's plaintiff's position, that's a question of fact for the jury. There's a jury instruction on that.
I understand all these instructions, counsel, but the question is, can it withstand that burden, or are we just going to take a whole pile of things to the jury and say, here, figure it out? But there's no evidence. And also address the comparative negligence, please.
There is no comparative. Ruth cannot be comparative as a 4-year-old under the age of 7, and no non-parties at fault have been named by the defendant. They cannot assert that this is anyone else's fault. We have not brought a claim for negligent supervision. There is such a claim. I have cases with it. We are not alleging that Lowe's was responsible for supervising Ruth. There's no standard that says that a 4-year-old can't be outside of a shopping cart. Now, again,
that's true, but as parents, I have 5 children, you have children, you know, they get into things that's in the store, they get away from you, and it's your responsibility as a parent to protect them. So I just want to know where this all fits in, because negligence, maybe gross negligence. I'm having trouble with the gross negligence.
Let's focus on the negligence, because that's the easiest part. The cases that defendant has cited are not similar to this case at all. There are cases where children are on property and they get into something that they shouldn't. They're back in the back of the store. Something falls on them. They fall into a vent. And then the allegation is, who should have been watching the child? If somebody had been supervising the child, this would have never happened. That's the allegation in those cases. Here, I go to stores with my 4-year-old all the time. If I saw her standing next to an employee, I would have no reason to believe she was in any danger, and the parents here didn't either. She had been on Nancy's hip, right hip, the whole time. I encourage my daughter to socialize with people when we're out, to talk to people. There's nothing, this might be a different case, Your Honor, if Ruth was running around, doing something that children may do, if she got into something and got hurt, if she fell into something. And then the allegation was, we're just a box store. We're not required to supervise her child. Understood. But as a human being, as an employee at Lowe's, if you're handling these big clunky scanners and there's children in the area under 10.07, you got to exercise greater vigilance. Now, there's no spectrum on negligence. The question of the jury will be, was there a duty that Miss Knight owed Ruth not to strike her with the zebra phone? And the answer is unequivocally yes. We all have a duty to pay attention, especially when we know children are there, especially when someone testifies that child's on my right hip the whole time. You have to be careful. And if you're not, and if an accident happens, we're not alleging this is intentional. This is not an assault and battery. We don't have to allege it's intentional. Just like in a car accident case, people say all the time, I didn't mean to do it. I wasn't paying attention, or I was fiddling with the radio. It's not an excuse. That is negligence law in Michigan and across the country.
All right, so to explain to me how we get to gross or negligent hiring of this woman who seems to be doing her job, but this accident occurs,
I'll cut straight to that, Your Honor.
Yeah.
We'll withdraw that.
Thank you, because that's going nowhere. It's just gonna cost them a lot of money.
We'll withdraw that
I
claim.
don't see, I didn't read anything that should never have been asserted, so, let's see, what else have you got?
I think defense attorney said, he was referring to one of the cases that he had cited, and he said, the child was in a place where they should be. Again, there is no allegation here to bring our case within the scope of the Wheeler case and those other premise cases. We did not allege premise liability here. This was not a hazard on the land that caused the injury. This was the negligence of an employee. That negligence is attributed to the employer. She's working within the scope and course. I don't believe that's in dispute. She struck Ruth in the head and an injury resulted. The extent of the injury, that's for the jury. That's not for the court on this motion.
So how do you get to gross negligence where it's willful and wanton? Again, you're reading both your briefs, I didn't see any willful and wanton.
I think it's a question of fact to the jury, but at this point, I'll leave that to the discretion of the court.
There's no gross negligence and there's no negligent hiring. The emotional distress and the negligence I'll leave at this point in the hands of the jury, where those two counts go. It just doesn't rise to the level of what you need here. And this is an accident, plain and simple. I don't know how the jury's gonna feel about it. I know how I vote just based on what I know, but I'm not gonna sit as the ninth juror.
I'm just wondering if I could do a
You
brief
can,
rebuttal.
you can,
Okay, and I appreciate
but
the
I've
conversation.
tossed two counts and, I mean, let's just tell me that what's not in dispute in the two that are left.
All right, yeah, as it relates to the negligence claim, I just point out the Wheeler case says this is the law. And this is a quote, as a matter of public policy, property owners should not be charged with the duty of supervising and controlling children of guests who have been invited onto their property, period. That's the law. Second of all, I will point out, plaintiff has to come up with actual admissible facts that exist in order to create a question of fact. What I keep on hearing from plaintiff's counsel in order to somehow, some way, try to create a genuine issue of material fact as it relates to negligence, even though everybody agrees that Nancy was doing scanning in a normal fashion, and everybody agrees to that undisputed fact, the comeback to that is what plaintiff's trying to say, well, wait a second. Nancy said that Ruth was on her hip the entire time. And then they say, and she was hit with a big clunky scanner, both of which lies and not based on any real testimony or facts. And in fact, Ms. Knight's testimony was, When Ruth was wandering around unsupervised by her parents, she was at one point before this incident in one of the aisles on her right hip. But she did not say that Ruth was on her right hip the entire time.
Okay, so and this is what I'm struggling with, counsel. You both have two different versions. When there's two different versions, I can't dismiss this case because there's factual questions that need to go to the jury. You're saying she was wandering, he's saying on the hip the entire time, there's no film. So the jury's gonna have to see which version they believe. I know which version I believe, but I'm not the jury.
Well, but it has to be based on facts, on testimony that has been submitted in response to this motion. And the only evidence that is about Ruth being on her hip, and I put it in my reply brief just to highlight, saying, lie, not no evidence of that. I say, this is what they're referring to. And she says, I remember going down one aisle and it was like she was directly on my hip, just following me around. Not at the time of the incident. The testimony at the time of this is she was not on her right hip at that time.
Stop right there. Was she on her hip during this incident? What is your version of this? Because I'm hearing the exact opposite. You just told me that she was at her mother's side the whole time. She wasn't a 4-year-old wandering.
She was on Miss Knight's hip. Miss Knight's own testimony, she stated that unprompted. Miss Knight said in her deposition testimony, the little girl was very friendly. She wanted to talk to me. She was right on my right hip.
Okay.
And she was right on her right hip.
On the employee's hip, she was there.
Yes.
It's a factual issue.
I'm just telling you, I attached the testimony.
I know.
Okay.
But if the employee knew she was there, she should have taken due care. I have dismissed, there's no gross negligence. I'm not gonna waste time entertaining that with the jury. There's no negligent hiring. She was doing her job exactly as instructed. I suspect they wanted information, they got it. The question of negligence, I'm gonna let this stay alive for a little while. You certainly can rebring this, but because there is factual dispute, I can certainly grant you what you want. They're gonna appeal it in the Court of Appeals the way they do, is gonna send it right back to us. I don't wanna belabor this. I think this goes to the jury. I have a pretty keen idea of what they're gonna do in this county, but at this point, your motion is only half granted.
Yeah, and I don't know that we went into big detail on count 3, the negligent infliction of emotional distress. The argument as it relates to, hey, this has to be a significant event that causes actual symptoms. I haven't heard anything.
But again, I think that will go to, if they find negligence, then that comes in. So I'm gonna leave those two alive, the rest go away. So you get a win on half, and you'll prepare the order, sir.
And as it relates to the denial as the other two, can I indicate without prejudice?
Yes, sir.
All right, I'll indicate without prejudice. And then counsel and I did want to bring up another issue to the extent this case survived. We have another issue, and I don't know if you want to.
What is the other issue? Is there a discovery issue or a timing issue?
Timing.
Before we get into that, Your Honor, I just want to clarify, those two counts are being dismissed without prejudice.
No. I can renew the motion. So the
I'm
two counts are
saying
being
two
dismissed.
are surviving and two are not. And as for the two that survive, he can bring another motion if he has cause to bring it, or a motion for reconsideration, or whatever the rules are. I'm not saying that neither one of you, and for that matter, you get some more information, you could bring a motion to amend. I'm not a judge that's gonna have a hard line on that, because cases tend to change.
Right, the denial on the two is without prejudice, and the other two are dismissed. Got it.
The issue that we're having, Judge, is that we recently opted out of case of L to facilitate with an attorney, Tim Sheridan. He was
Okay.
going to facilitate this matter. We just got word that Mr. Sheridan cannot facilitate. He has a conflict. And,
Okay,
so what we would like is just a little bit more time. I think we would
Sure.
trial date.
you're gonna extend everything out like 60 days
Well,
or 80 days or something?
Yeah, it's even broader than that. So, and as we also discussed, I now have Shiner's report. I've been asking for it for
Okay.
months.
Okay.
And then Seawick has still not generated. He says in his preliminary report that he's going to be generating an additional report. He has not even done that yet. So we have that expert related discovery that we have to do. I've also, as soon as we get those reports, I'm going to send Ruth off for an IME, see what's going on there. So we're going to need some time to do that in addition to.
So 120-day extension on
I think
everything,
that
or
would be.
what?
I think
All
that
right,
would
we
be-
got 120 days, put that in the order, thank you.
Okay.
Thank you, Judge.
And
Thank you,
as to a trial date, because, we have weeks of criminal, weeks of civil, so just get a trial date on my civil docket from, my judicial assistant, but the rest just extend it out whatever dates work for you, and those will be fine with me, but the trial date, you'll need to look at your schedules along with mine, if that's okay.
All right, that sounds good. Yeah, because we do have an August trial date right now, so we're.
Yeah, that won't happen.
Right, okay.
No problem.
All right.
Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you for all your briefing and information.
Yeah.
Appreciate that. Thank you. It's all for the record. Next.
Next is the criminal matter.
Okay.
He was Bridget from Clinton County, so is he downstairs?
He is
Okay.
downstairs, we should call down and ask.
Who is it?
Amory.
No. So Aquilina, good morning. May I have Amory? Luke, don't you miss those civil days? So let me ask you this, are we, because there's been so much of a history here, we're just dealing with the 866 and the 868 files. I have 4 files, the rest we're taking care of.
No.
No.
He also needs to be sentenced on the
227.
227.
And then I have the nolly on the
Oh, the
226.
227, okay, so the 226 will be now,
Yes, and I have that nolly right here.
okay. We need to wait out of this.
No, they both agreed to everything they had on their
Yeah,
spot.
there's no lot right now. Okay. What's this?
This is a big.
Okay, I think we've got all the paperwork squared away. All right, did you need it? Did it with your client?
No, yeah.
All right, this is docket 254866FH, 254868FH, and 22227FH, and then 22226FH. I believe those are the 4 cases before this court that we will address today. And this is People of the State of Michigan versus Michael Amory. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Amory in all of these files.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, ma'am. Yes, Your Honor.
You put your hand down. Have you had enough time to speak to your attorney in regard to all these matters?
Yes, Your Honor.
Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, besides the Tylenol, I just took the Tylenol, that's it. Just-
Well, okay, so, but that's not going to interfere in your
No.
ability to understand the court or your attorney. That's why I asked.
No, Your Honor.
All right. You feeling okay today? Any sign of fever, COVID, or other illness?
No, ma'am.
All right, very good. Sir, I have a pre-sentence investigation report on 254866FH and 254868FH, where you pled guilty on the first docket to count 1, financial transaction device stealing, retaining without consent, punishable by 4 years, and then a second count of that same violation, financial transaction device stealing, retaining without consent, 4 years. And then on the second file, the 4868 is stolen property, receiving and concealing a motor vehicle, punishable by 5 years. Do you recall that?
Yes, ma'am. Yes, Your Honor.
And then on docket, looks like it's 22227FH, you pled to retail fraud, first degree, punishable by 5 years. Do you recall that?
Yes, Your Honor. Yes, Your Honor. I'm sorry.
All right, thank you very much. And on behalf of the people, and I do have, let's make a record, I do have the pre-sentence investigation report that has the first 2 files that I mentioned, the 4866 and the 4868. And then there's another PSIR for 22227FH that counsel provided to me because I did not have it. This is an old file. And so we need to go through and update and correct both of these PSIRs. So as to the people, how would you like to proceed?
Yes, Your Honor. Let's start with the 22-227 matter, and then we'll go to the more recent one.
Is that all right with you, Mr. Goodrich?
Yes, Your Honor.
All right, thank you. What are the corrections? I do see some that have been made, because I did receive a patent from Mr. Goodrich. So he is now 37 years old, and the sentencing date would be today's date, which is June 25th, 2026, and that will have to be made throughout. Additionally, do we need to add correction jail days and range on this or not?
No, Your Honor, because he technically hasn't been held on this case at all in the time being.
All right, thank you very much. And it looks like the under evaluation plan, the age and date of sentencing needs to be corrected in the first paragraph as well as the second one. And then we need to go to the basic information sheet as well. Where that is now, I don't know, it was in a different place a couple years ago, let me find it.
I think it's at the end, Your Honor.
There it is, okay. So then we need to change the sentencing date on the basic information sheet to today, that's on page 1 of it. And it is in the back of this one, they started putting them in the front, so.
Other correction that I think we need to make, Your Honor, is that the attorney at the time was Ronald Berry.
Yes.
Obviously, Mr. Berry is no longer here, so I believe that Mr. Goodrich's name should be put in.
Mr. Berry was there for the plea though, correct?
Correct.
So I'm gonna put him as plea and then Lou Goodrich as the sentencing attorney.
And that issue also comes up in the first paragraph of evaluation plan as well.
Yes, I'm changing that to I'm adding for plea and Lou Goodrich. For sentencing. And then we need to go to the criminal history and instant events and change the sentencing date to today's date, 25 June 26. And then I think on this one, we have everything, unless you want to update family, marriage, employment, anything like that.
Your Honor, we would ask that it show that he's now employed at C and E Painting.
C and E painting,
Yes.
start date,
When did you start?
About 5 weeks ago.
so what is that,
About
May?
May 1st, roughly.
And that's current,
Yes, ma'am.
and what is your position?
I'm a painter, MSU painter.
And what's the rate of pay?
I made $18 an hour.
Okay,
Your Honor, the one other issue regarding the body of that report is the criminal history between these two documents have several discrepancies between the two. Perhaps the court could adopt the criminal history from the most recent one that we received, numbers 1 through 25.
okay. I will do that, I'm just gonna make a note on here. There's no objection to that?
No objection, Your Honor.
And then offense number 18 of 25 would be the instant offense in the 227 file.
Okay, let me. Okay, so the 18 of 18 is instant offense.
No,
I'm sorry.
there's 25 offenses in the
25.
document we haven't got to
Okay.
yet. And 18 of 25 of that group is the instant offense.
I got it, okay. And I'm changing that date to today's date.
Yeah, unfortunately, there's a couple offenses in each one that doesn't appear in the other one, so the numbers don't match up. So that's why we're
I'll just
asking
have to figure that out.
the court to just adopt this
Okay.
history of the second one.
Okay. Great, thank you. So the 23 of 25 also says instant offense, and that would be for today.
That would be on the new.
The new one, so that date also needs to be changed to 25 June. Okay. So I think I got it on the new one.
And then, Your Honor, 21 of 25 is also the other instant offense that we hear for sentencing on today. So that would need to be, the sentencing date would need to be changed on that as well.
Okay, so it says pending, so I'm taking pending to instant offense. And then changing the sentencing date. And I think we've got it all covered in this report. Okay. So are there any other corrections we need?
Not to the body of the 22 matter, Your Honor.
Your Honor, the only thing we would have is the same C and D painting change.
Okay, let me make that in just a moment.
Oh, if we move to the 25 case, in the 25 case, I do have some changes on.
Do you have a section on looking for it?
They might not because it's an update report, Your Honor. and
Yeah,
usually you don't do-
It's not there, so they'll have to combine these reports.
It would be on the cover page.
Oh, on the cover page? Okay, I got you. So, that would be, what did you say, C and
C and E.
E painting? Okay, great. Thank you. Any other corrections?
Nothing further from the defense, Your Honor.
On behalf of the people, did you have any other corrections to the body either? Otherwise, let's go to the guidelines.
I just want to make sure I know what PSI we're on. Are we still on the 22 one? Or have we moved to the 25 one?
We're on the 25 one.
Okay, so if we move to the 25, I don't have any more changes to the 22. In the 25, the sentencing date does need to be changed throughout.
I did change that, but then do we need to change any jail credit on that?
Again, Your Honor, there would be no change there. He is currently being held on a driving with license suspended matter in Clinton County, not in Hingham County.
Okay, and then.
So then, yes, no other changes to the body of the report in the 25.
Okay. And what about guidelines?
Yes, Your Honor. So going back to the guidelines of the 22 matter for a moment.
Okay.
And it should already be marked up in your copy, as it is my copy.
Okay.
PRV 7 was scored at 0 points. PRV 7 is subsequent convictions. As he is now pled to these other charges, PRV 7 should be scored at 20 points.
Any objection?
No, Your Honor, but to clarify, I believe Mr. Buxton's referring to the 22 file.
Yes, correct.
That's what I understood.
Yes.
Thank you for clarification. All right, so then that's a total of 75.
75, and then level E, and that would change the guideline range on that case from 9 to 23.
It's still level E? Or did it
It's
go-
level F, Your Honor.
F, that's right, okay. So it goes to 9 to 23?
Correct.
Okay, I'm changing it to that, okay. Yeah.
And then I don't know if we want to make that change then on the PSI update case report for that.
Yes, we have to do that. So I've changed it to the 9 to 23 and the PRV at 75, and we're all consistent. All right, and now can we move to the other report?
Correct, Your Honor.
Okay, and what are changes, if any, on the guidelines here?
Yes, Your Honor. OV12 is currently scored at 0 points. However, on both financial transaction device, please. However, Your Honor, for both of those, that should be scored at 5 points. As there were 2 other financial transaction device stealing/retaining without consent that were dismissed as part of this plea. So OV12 should be scored at 5 points.
Your Honor,
These two.
Your Honor,
Yes.
yes, I would agree with that for the case, the case with the financial transaction devices, but then leaving it at 0 for the receiving and stealing a stolen car. case.
Correct.
Okay, so then the total would be 11?
Total will be 11, Your Honor,
Does
correct.
it change anything else?
That does change it from a level
1,
1 to 2,
okay,
and that does change the guidelines to 2 to 17 on both. And then no changes to the receiving and concealing motor vehicle.
okay, so let me then change that to basic information sheet, so counts 1 and 2 would be total 11. And then 2 to 17, changes have been made. Do we need to change that in the, did they do the recommendation narrative? Yes, recommendation narrative would be, for counts 1 and 2 would be 2 to 17, that change has been made.
And then, Your Honor, I
I'm
apologize
sorry.
to go back, but I
The
don't,
range, just a minute, so the range then also. It was the range, 2, yes, 217. Okay, I'm sorry, what?
I don't think we changed the guideline scoring and guideline range on the cover sheet of the 22 case. Or I don't know if you have. I'm doing that right
The
now.
guideline range on I've changed the guideline, I've changed all, guideline ranges, OBPs, whatever, on both, on the basic information sheet of both.
Okay, just wanted to make sure, thank you.
Okay, now are there any other changes?
I don't believe so, Your Honor.
Okay. And do we have a victim who wishes to address the court on
We do
any of
not.
these files?
We do not, Your Honor.
On behalf of the people, what would you like me to know?
Yes, Your Honor. Mr. Amory, as you can see, it keeps picking up cases in regards to property theft, both money as well as vehicles. I do believe that the recommendations on all of these cases are appropriate. However, I just want to clarify in regards to restitution. I believe restitution is already all listed in the 22 matter. That being $2,993 with $1,130 going to USA 2GO at 4495 West Holt Road. $1,483 to 7-Eleven at 1977 North Aurelius Road, and $380 to Sparty Liquor at 2005 North Eifert Road. In regards to the new cases, Your Honor, and I will also say in regards to the 226 matter, it looks as if our office did contact the victims in the dismissed case. And there was no provable restitution in those cases, so we would not be requesting restitution in the case that will be dismissed after this sentencing.
Has he violated the Killebrew on this 254866?
He has, Your Honor.
4868, because I'm wondering why, I mean, the agreement was that you go to treatment, but we went in a couple of years from 18 to 25. What are we doing here?
I would agree, Your Honor. He has violated it because he did fail to appear at a previous, I believe he failed to he's picked up additional charges as well, Your Honor. So I do believe he has violated the Killebrew agreement in both cases, Your Honor, at the very least the 22 one. Additionally, Your Honor, so I actually would ask that there be a sentencing within the guidelines, Your Honor. Additionally, looking at these cases, I did have a chance to talk to the victim of the financial transaction device. One second, I have to pull that up on my computer.
Heather Abood?
No, Your Honor. Kisha Nabel.
Oh, Kisha Nabel, okay,
yes.
there's two, okay, yeah.
Yes, I had a chance to talk to Kisha Nabel in regards to the restitution. So reviewing the documentation and talking over the case with her, it appears that some of the transactions were returned by the bank. However, a total of $260.70 were not covered and returned by the bank.
So in lieu of the 616.45, it would be 260.77?
Correct, Your Honor.
I take it, Mr. Rivers, you have no objection to that?
We are not objecting to that yet.
Thank you.
However, Your Honor, she has also stated that as a result of finding out that her transaction device was being used at this time, she was actually out of the state and on vacation and had to cancel plans to immediately come back to Michigan in order to handle this situation and get in contact with police. So she would be requesting that money. I do not have that money as of yet, so I'll be requesting that restitution be kept open.
Wait a minute, I guess we do need a restitution hearing on that, because my thought process on that, because I think it's just sadly too common that people use credit cards of others. I've had that happen. I call the bank, they cancel it, it stops it, they do an investigation. I have not changed my work or personal life, traveling across the country from wherever I am to handle it. So can you explain that more? What more did she need to do than report to police and the credit card company?
That's the information that she gave me, Your Honor. Like I said, I would just be asking it to be open at this time for a potential restitution hearing later in the future, so I can get additional information.
Okay, I mean, I don't mind victims getting compensated, that's their right, and I agree with that, but I'm a little concerned about that explanation, so I do need some more details. You can find that out for me.
And I would be, Your Honor. And like I said, I'm not requesting an amount right now. I would be keeping restitution open at this time to have a potential restitution hearing for any additional payments that she may have made as a result of this incident. But as of right now, she would be requesting and is documented $260.70.
Thank you. Anything else?
No, Your Honor, thank you.
And counsel first as to whether or not he's breached this agreement, because we have one file, I have 4 files, he failed to show. We haven't seen him, there's lots of things going on here. He went from 18 in the one file to now 25. Explain to me why I should honor this agreement, because I do believe, and I don't want to believe, I want to know that he violated, and it does appear to me he violated all of his agreements.
Well, Your Honor, regarding the more recent matters, I believe the court did find that he missed the date to do his pre-sentence interview, and that got rescheduled after he was in jail for a couple days. He got interviewed and was released. Your Honor, he has been at the vast majority of his hearings in matters as these cases have gone along. The reason that plea was negotiated in the first place was due to Mr. Amory having some long-term substance abuse issues. And I think that was the goal, was to address some of those issues. And I think a term of probation would be appropriate for him, because that's, I think, the underlying root of that some time in jail or prison is not going to alleviate. We would just be right back in the same place a couple of years from now if the court wanted to go down that road. I would ask the court to place him on probation, order that he do some type of treatment. He has told me that he has been staying away from drugs for a while now and would like to do outpatient treatment so that he can continue to work his job, because he's had a hard time getting employment over the last several years, and he's recently gotten that painting job. He currently has a driving license suspended matter in Clinton County that has got him incarcerated for a few days here. But I believe he's going to be able to get out of the Clinton County jail within a day or two, is my understanding. So we would ask the court to, like I said, give him the opportunity on probation. If the court feels he needs long-term residential, he would be willing to do that. Though, like I said, he would certainly prefer to do outpatient so he can continue to keep his job. He has a son that graduated from high school this spring and is going to community college in the fall. And I know he wants to both be able to help financially in that situation, as well as spend some time with him before he goes away. So we were asking the court for that opportunity. I think he could be successful on probation, Your Honor. And like I said, I think that the underlying drug issue is what's been a common thread with a lot of these type of theft offenses. If you look at his record, you don't see a lot of violence or anything like that. It's a lot of theft. So we would ask the court to essentially go along with the initial plea offer in the case, even though the court does not legally have to do that. But I think it's appropriate here and would benefit both Mr. Amory and society if followed. Thank you.
Sir, what would you like me to know?
Well, I'd like you to know that I accept responsibility for the things I've done, and I'm not blaming anyone. And I have bettered myself a lot. And as far as in my son's life, I feel bad about like a lot of the stuff I've done, and then when I get back better, I try to fix it with money, and I realize money is not about to fix a lot of the time and stuff that I missed. So like me, when he just graduated, thank you for letting me be able to go to his graduation, and he has a open house coming up soon. I would like to be able to go to that. I realized that I do need, I went to rehab once here in Holden House in Lansing, Michigan, did it. And that helped me a lot. I haven't been in usage lately. I got picked up on this Clinton County thing. It was messing me up. But basically what I'm saying is I feel like I can do good. And me having this paint job is like a whole new step up. And for me to lose it would be actually a big punch to me. But, you know, I feel like I could really, step it up, pay this stuff off and get back on a good pace of my life. I want to be around for my son's open house and stuff. Really, I feel like I won't be able to get a chance to do that stuff again, but I take responsibility for what I've done, and stepping up to the plate. I'm ready to get this stuff behind me, and yes, man, I'm trying to do better, be a better person, or overall, no more that stealing stuff. That stuff is in the past. I need to work hard to get to what I need, do what I gotta do.
You've been in trouble for 20 years. You were given higher probation to earn non-public record in 2006, and you were revoked, meaning you were cracking. You then had a lot of counts that were annihilated. They were dismissed, but you also had a lot embezzlement, disorderly, disturbing the peace, operating while license suspended. Here we have another one that's still pending. Income tax violation, controlled substance, delivery manufacturer. You have got a history here, sir, that you didn't care about your kids, family, or community, and now you want me to care. I let you go to graduation. It is a once in a lifetime. I'm glad you got employment, but you can get that employment again. They're looking for painters all the time. I see the ads. You owe restitution, so I'd like to put you to work. But sir, you need treatment, and it's not your choice, it's my choice. And this history smacks of prison. It smacks of prison. Do you understand that, sir?
Yes, Your Honor. Yes.
And let me just check this out here. I want to go to the report that has your family here. So your son was 14, so you missed most of his high school, then you got to go to graduation. Is that the only son you have, or are there children for?
That's my only child.
All right. Well, and did you ever pay child support for him?
Yes, I paid child support and especially to my last job, which was 5 years ago. I was paying child support, but they racked up $220 a week on me for 5 years when I didn't have a job. So it was $80 a month while I didn't work. So that's what racked up a lot of my.
Well, see, sir, it's not that you have a child and then you can be unemployed and not pay. You still owe your fair share. It takes two to play and it takes two to pay. So they can impute income and say, well, he's capable of working, so you still gotta pay. Don't tell me you weren't working and then you couldn't pay, because every parent who doesn't want to pay for their child will just stop working.
I wanted to pay.
Well, for 5 years you didn't work? Where were you?
I was
Using
MIA.
that money, you were not MIA, sir, let's get real.
I wasn't working.
You weren't working. You were working on your drugs. You were using whatever money you could that you stole from people to use your drugs. Let's be real honest, sir. That's what this history shows. Is there something I missed?
Yes, I was just saying I've been $22.20 a week without a job charged up, so it added up to a lot, and I didn't have a check coming in. That's what I was saying.
I got that
I
part.
take responsibility.
That was your fault.
Yeah, I take responsibility.
They shouldn't have assigned you zero because you weren't working and you were spending your money on drugs. They were sending you a message, do your job. Do you have an arrears of child support?
Yes, I do. Me and the mother of my child has been working that out I just started working. So she said if I could pay like half of it off, she was gonna help me out so I didn't have to get in trouble for that. But I'm giving them some money. I've been doing a little better lately, trying to communicate with them.
So the other issue I have with this report, this old report, it says substance abuse history, no, when it is documented in the report, yes. So that should be a yes. And this other report, the old report, it should say yes. And it looks like cocaine was your drug of choice.
Marijuana and cocaine.
Yeah, marijuana to alcohol, marijuana, and cocaine. Mm-hmm. So here's what we're going to do, sir. I want to be very, very clear with you. You're going to go to residential treatment. You might not like that, but the other option is prison. So today I'm going to give you a choice. Residential treatment that you complete, including all aftercare, or you get treated in prison. I understand they have exceptional programming lately. What's your choice, residential treatment or prison?
Residential treatment. Is it possible I could go to a holding house in Lansing, Michigan? I did that before. It's residential.
You can go wherever it is, wherever probation works out, where there's a bed, could be holding house, it could be something else. What I want is a program for you that deals in cocaine. Some are better for meth, some are better for heroin, some are better for cocaine. So if holding house works, great. If not, it will be some other place.
Yeah.
What?
I was gonna ask, because I'm gonna be getting released from Clinton County, he'll probably be here in a couple of days, and then within a week, my son's open house there. So
Don't care.
I was just gonna ask if I could
No.
possibly go to his.
No. I let you go to graduation. I'm sorry you can't go to the open house. You are gonna miss it. Have somebody take some film. That is the price of not prioritizing your community or your child all these years. You should apologize to your son, although I feel like I should, I'm not going to. When you commit these crimes, because seriously, sir, when I looked at your files, I'm thinking prison, prison, prison. You are lucky you're getting residential treatment. You've ignored this court, you've ignored your community, and let me tell you, those drugs you use, you think that your child is going to be immune from being offered those drugs in college? They're gonna be swimming all around you, and you are part of that problem. You want that for your son?
No, no, ma'am.
Then be the example that you're taking the route of rehabilitation, taking it seriously, that you can make a mistake, but you can make amends. And this is the consequence. As to docket 2227FH, he will be on probation for 36 months. As to docket 254866FH and 254868, he will also be on probation for 36 months. These will run together. On the 227 file, he has credit for 56 days. On the 4866, he has credit for 71 days, and on the 4868, he has credit for 68 days. He will serve 365 days on all three files with credit for those days. The balance is held. If you do poorly, sir, I may use that jail time, but I also may send you to prison. So in lieu of the jail right now, going to jail or prison right now, I am going to send you to residential treatment. Holden House, if they can deal, if that's the best one for cocaine. Otherwise, wherever there's a bed available. If you remain any other days, you'll get credit for those days because you are going right from jail to treatment. You will sign all necessary releases and complete all aftercare as well. I know you said you've been doing better lately, sir, but it is better that you missed your son's graduation party open house than have your son be a regular at the cemetery. Cocaine hurts your body. You don't know if you're gonna take the last hit and die. So you imagine your son grieving over all the time you've missed with him on top of you killing yourself with drugs. And I am certain that if your son were here and I said, you want your dad to come back healed, or you want to go to open house, he'd want you healed in one piece so that you can enjoy this college graduation, the children he'll bring into the world and the great things he'll do. So hopefully you will strive for the life that God gave you, the greatness you were born to. Otherwise, some cemetery will be happy to bury you, sir. Or some prison will be happy to accept you and try to rehabilitate you where I have failed. Those are the only options, sir. You have choices to make. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. Nor any weapons, guns, ammunition. You'll not use any object as a weapon. If you have the need for any paraphernalia or drugs, I will present a prescription from a licensed medical physician, only use those as prescribed. Alcohol and marijuana included. You may not use them recreationally. However, if there's a prescription, you'll use them as prescribed. You will attend aftercare from whatever treatment program is found. Holden House is fine, but again, I want the best one for you, and I want it to be long-term residential, including aftercare, which will include AA, NA, or CA, that you will attend at the frequency recommended. You will have a sponsor within 180 days of your release, and the sponsor will have gotten clean and sober by attending one of those programs and be clean and sober for at least 5 years. You will also participate in cognitive behavioral treatment. That should be part of programming that you are attending, so it can be separate, but it also likely is going to be included in your residential treatment. You will not have verbal, written, electronic, or physical contact with any of your victims. That includes Keisha, K-I-S-H-A-N-A-V-A-L. And that also includes Heather Abood. And you will not enter any Sparty liquor or 7-Eleven or USA to go, regardless of what the location is. You will not be within 1,000 feet of the victims. That would be Keisha or Heather. And you will not be within 1,000 feet of their residence, school, place of employment, or any one family. I don't know if you know these people or not.
No, I do not.
So what happens, sir, if you end up at Myers and they say, hey, it's you, get away from me, because they might recognize you, just do it about face and leave. Don't engage.
Okay.
Sir?
I had a question about the last time you put it on the record that I was supposed to receive my things back that was in the car. I just was wondering about if that was still.
If
you
you're
said-
supposed to receive them back and they're not, so
That's-
law enforcement keeps certain things for a certain period. So as soon as you are eligible to receive those, you'll receive them back. I think I did do that prior order. Now that you reminded me, I did do that. So I don't know what was in there. Is it anything related to the crimes?
No, it was a lot of my clothes. It was a lot of stuff. I was in that.
Okay,
It was
so-
a lot of my things, stuff. I don't know.
Law enforcement should return those to you. And Mr. Goodrich, if you want to prepare an order, so we can identify that, or you can take that, that'd be fine. I'd be happy to sign it. You'll obey all court orders and recommendations from all treatment providers, including probation. Those become orders of this court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections without permission of probation or who's on probation or parole. If you end up working with someone who's on probation or parole, that's fine, but you need to let us know, and you all need to be in good standing with the court. You'll contact probation within 24 hours of your release from your residential treatment, and you'll allow probation to residents at any time for probation supervision without a warrant, and submit to a search of your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to probation within 24 hours. Weekends and holidays are accepted, and that includes personal protection order if any is placed on you. So if something happens on a Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will maintain employment. I suspect as soon as you get out, you'll be back to that painting job. They're looking for painters. If not, you'll be part of a work seek program, and you will obtain employment through that. Once you're gainfully employed, you will not work less than 30 hours per week unless you become a full-time student. Then it would be 20 hours per week. And you will not give your employer any cause to terminate you. If you want to change employment, you'll first get permission from probation. You will arrange a payment plan for your child support, so we don't end up with another file for non-payment of child support, and pay that regularly. We'll also regularly pay restitution. The restitution is as follows: $260.77 to Keisha, $260.77 to Keisha Naval, Naval. And that will be open for 6 months. In the event she wants to pursue those other costs, or you dispute any of these amounts. As to probation oversight, I'm waiving probation oversight cost, finding that you are indigent. As to crime victims, on each file, you'll pay $130 on each file. And then on the file that is the 4866 file, you'll pay $68.20 twice because there's 2 felonies, and then on the 4868, you'll pay $68, and then on the 227, you'll pay $68. Those are state costs that are non-waivable. The recommendation here is for TRICAP. You can work with the jail and probation to see if TRICAP's better or Holden House. I only take the position I want what's best for the issues that you have. You will not engage in any criminal activity, nor will you run a business or work for an employer where you have access to funds, credit cards, etc.
I can't have my own business. Like if I was to do lawn care, painting or something.
Well, we'll talk about that, but if you're taking monies directly from people or using their charge cards, no, not right now. So maybe you want to have a business manager who does that, but I don't want you with this history here, sir. I would be remiss to say, oh yeah, let's give you people's credit cards. No. But if you have a business manager, you have some protections in place, I'm willing to entertain it. So, but the crimes that you have here of defrauding people, I don't want you to work in any job where it's easy to defraud, overcharge, or have access to checking accounts, charge cards, and the like. Understood, counsel?
Yes.
You can explain that to him further. I know you know what I mean. All right. You will not adulterate any test. You'll be regularly tested. If you are found positive for any alcohol, illegal drugs, then there'll be a secondary test done that you will pay for. And we'll see if it's a positive or a positive negative, and we'll figure that out. Holden House or TRICAP should transport you unless they make an arrangement with the jail or the jail transport. So I don't know, that's between them. Once I sentence you, the jail takes over and they'll figure all that out.
Is Bear River an option?
Bear River's also an option. It's an excellent place as well. So here's the deal, sir. I don't know who has beds open. What I want is the one that's best for your addiction and whatever trauma you've gone through, so you can get it all handled. And there needs to be a bed open. So the sooner we have a bed open, the sooner you get out. So Bear River's good, Holden House is good, TRICAP's good. You're gonna work that out with the people the social workers who know it best.
All right, I'm in Clinton County right now, so I'll just figure that out, I guess.
So, well, Your Honor, your sentence is essentially that you would do 365 days in jail, suspended upon placement in residential treatment.
Yes.
So the sentence would be suspended as soon as, that would essentially create a hold for you from Ingham County. So when you're done in Clinton County, you'd be brought back to Ingham County, and then you'd be sent
For a year?
No.
You would be sent to rehab, and as soon as they find a bed for you, your sentence in Ingham County would be suspended at that moment, so they could send you to residential treatment.
So I'm just holding that jail time. If you want to commit any other offenses, go AWOL on me, whatever, I can send you to jail. I could also send you to prison. I'm just holding that place card just in case we need it. So you're only doing the necessary time so you can clean up all these matters, and if there's a bed, they'd be transported to. If Ingham and Clinton have an agreement where you can go from Clinton right over to treatment, I'm okay with that, because maybe the judge there will put you in treatment and agree with this. So that would be fine with me too. All right,
I'm
now,
supposed to bond out today, so I might as well just not bond out then.
well, you can't bond out on what I'm doing.
I know I was talking about out of Clinton County.
You can bond out of there if you want. I don't know what you probably want to handle all that, because they'll probably look at this and say, okay. I mean, they usually we all judges try to vary up things to make it easier for the system and for you. So I don't know. You talk to Mr. Goodrich about that. All right, now, there's other restitution here. Doesn't look like Heather Abood is requesting any, correct?
That is my understanding, Your Honor.
And then on the 227 FH file, the restitution is as follows. A a total of $2,993. That breaks down to $1,130 to USA to go. And that's at 4495 West Colt Road. $1,483 to 7-Eleven at 1977 North Aurelius Road. And $380 to Sparty Liquor at 2005 North Eifert Road. If you dispute any of these, we'll have a restitution hearing, and certainly if that other matter comes up and she's requesting that money, we'll have a restitution hearing. I would think that would be warranted. Is there anything I've missed on behalf of the people in regard to either of these?
No, Your Honor. And I do have the nollie on the 22-226 matter.
And I'll be able to sign that, and then I'll give Ms. Wrights in just a moment. Is there anything I've missed?
No, Your Honor.
Any questions, sir?
I'm a little bit confused.
About what?
All like talking of the different monetary things. I was just a little bit confused.
The monetary, let me explain the monetary. You stole from people and they're entitled to restitution to make them whole. If you disagree with the amounts, let Mr. Goodrich know.
Oh, no, I wasn't talking about, I was talking about like, it said like 260 plus 264 times the 60. I was confused about like a lot of the
The
fees.
$68 is a state cost that.
I didn't, yeah, a lot of those fees, I didn't know.
Yeah, well, I don't hold cases open for that. There's a $68 cost that is a state cost that they impose for each felony that you pled to. So for each felony, you pay $68. And then on each file, there's a crime victims fund that is funded that you help, every felon helps fund at the rate of $130. So you have to pay those. I don't hold files open for that. That's the last thing. You'll pay restitution before and child support before you pay those. Those are the last things you pay, and I don't hold files open for that because I think that the state's a little bit silly on collecting that money from indigents, but that's not my choice, that's theirs. So you have to pay that because that's just the statute. So if that's not a grievance with me, talk about that with your senator or representative.
All right, in the last year, I've done about 6 months in jail for child support, and she just gave me an open thing until September. So if I do.
You'll just arrange whatever child support, whatever the agreement is, the agreement is. I just
She's gonna
want you
put
to
me
pay
back
for
in
it.
jail right when I get out of basically treatment, if I was gonna say. She's gonna put me right back in jail because she did it until September. So I
Who
don't,
did what till September?
the person that cured, that amazed my child support, they put me in jail twice like that. I was supposed to go 1 month. She put 1 month, two months in a row, and then I got out, and then she did it again. She put me in jail 2 months in a row. So she said, so yeah, so she said she messed up, and she's like, well, okay, well, we won't do this again until September. She's like, we're gonna have it open so I can get a job. So she said, but then by then I'll probably get a jail sentence. So if I'm here and then I go.
You're gonna be in treatment probably for 90 days. You just get the documentation, show her you were in treatment. And usually there's an exit plan. So you have a place to live and they'll help you get a job and all of that. So you show that to her. They're gonna probably be really proud of you for doing that and not ding you for it. I would hope not. So, and Mr. Goodrich could have a chat with them, or whoever your lawyer is, can have a chat with them and talk about what happened here. We can get you a copy of the transcripts. There was something else you said that I just thought of. What was it? Well, let me ask you this, Mr. Goodrich, would you like a copy of this transcript sent over to his family court judge or worker?
Your Honor, if not a transcript, just maybe a note that, I mean, even some type of simple communication from your office to the friend of the court that he is going to be in residential treatment for the next, 90 or whatever days.
We'll just send a copy of the court note highlighting that he's going to residential treatment, and hopefully he's not dinged for this. If they have more questions, I'll just have the sentencing part of this sent over. This transcript sent over, and I can have the law clerk talk to, who's the judge? Is it Clinton County or Ingham?
Ingham.
Eaton?
Ingham.
Ingham, who's the judge, do you know?
I don't know.
Okay, well, it's in this building, we'll figure it out, and we'll let them know. Is there anything else? So you'll just arrange a payment plan for child support, the restitution that you owe, you're gonna get a job. If you miss one payment, we'll have it come from a wage assignment. You understand, sir? You got some skill, you went to school, but don't you have some college too?
Yes, a little bit.
Well, you could go back to LCC under the Reconnect program for free.
They won't let me get back in school. I've been trying. They will not let me get back in school
Why?
because I took some of the loan money out and I haven't paid it back. When you get the first money back.
Okay,
So I don't know how to get back in school. I've been trying.
well, LCC has a Reconnect program that's for free. I don't know, there might be a loan forgiveness, you gotta work that out. Maybe you can work a payment plan on that too, sir. You might need to
They say
reach
you
out
have to
to
pay it
this.
fully off. I have to pay it fully off to go back to school.
Okay, well, how much you owe?
I think I only got $7,000 from them.
Okay, well, figure out a payment plan before you know it, it'll be paid. Maybe you need to work an extra job.
I haven't been able to get any jobs just until recently.
Sir, you can paint, Myers hires felons, there's lots of places, all these warehouses, they pay really well. I mean, there's a lot, I have felons in front of me all day long, every day, and they are employed, and some of them have worse histories than you. There will be people who will hire you, just quit having open files, there's not gonna be someone who hires you so that law enforcement can go on the job on their premises and arrest you. Stay clean, make a commitment to yourself, the community, and your child. Have some respect for yourself, sir. The only one who's failing you is you. Be your own best friend. Look in the mirror every day and say you're worthy of doing better, that you're going to reach for greatness and attain it.
I've been clean the last 6 months. I haven't been using.
Great.
I have not been using any
Well,
drugs.
6 months is gonna turn to 7 to 8 to 9 to 10, but we need to see that longevity, because I suspect when times get hard, you turn to drugs. We're gonna change that pattern, but you gotta want it, sir. You have 42 days to appeal and to request appellate counsel. Do you acknowledge receiving your appellate rights?
That was it.
That's what that is. Someday you come back here and show me the great things you're doing, and maybe we'll have a picture of you and your son. How's that? Good luck to you, sir. Will you print out an extra copy of that court note? We're gonna highlight where it's going.
Yeah.
Send me on to whatever.
You wanna take
Okay.
Work your day.
I can read it.
Might be 3 days.
How come they never-
I'll
just
look it up.
Yeah, just put them all together.
Yeah.
We're gonna be what?
It's gonna be 3 and 3 JOS.
Yeah.
That's 5 for the restitution.
Yeah. It's all in there, and then you can see the numbers and I'm just very well.
We don't know.
There was an 11:30 civil matter. It was a motion to dismiss. There was actually no motion ever filed.
Huh?
There was no motion ever filed. This, Mr.
Wait a minute, what is
Mr.
this?
Parker, the appellant, is here. It was a motion to dismiss, it was set for, but there was no motion filed.
Who is? Wait, who is he, Mr. Parker?
Yeah. He's the appellant.
Who said this? The plaintiff?
The, next judge, I believe.
What text is that?
11:30.
Harry, come on, go down the record.
Okay.
Yeah, this is docket 262348AB. Next Bridge Funding LLC versus occupant. Are you occupant, sir?
Yes, I had the house phone and
They just didn't, it's okay, they just didn't know your name and you're supposed to be paying. So your name is Joe Parker?
yes, ma'am.
So we're gonna amend, first of all, the caption to, is that your legal name, Joe?
Yes, Joe, J-O-E.
Okay, Joe Parker. I'm adding Joe Parker, occupant, I'm Joe Parker. worker. So we recognize you as a human being, not just occupant, it could be anybody. Okay, and it looks like this is plaintiff appellant's motion to establish rent escrow. Sir, please raise your right. Huh?
That's not the motion. It was supposed to be a motion. We've already signed, we've already signed the escrow. It's supposed to be a motion to dismiss from.
I know this is the third time, because they had 2 Zooms, but you got this.
So there's an order directing escrow payments, which I signed. Where's the motion?
There is, that's what I'm saying. We didn't get a motion to dismiss file. Like, I don't see one in the file anywhere.
Did you file a motion to dismiss or did they?
They must have filed when they sent me a thing saying I'd be in your courtroom today at 11:30 for dismissal.
Okay, just a minute. Is that on our docket? Yeah. Okay, where's our docket? So have you been making payments, sir?
Okay, first when I sent the
Wait a minute,
payment,
do you please raise your right hand? Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
yes, ma'am.
Okay, make your journey back. I just want to ask a couple very quick yes no's, okay? And I agree, I know you want to explain things to me, but I don't know if that's in your best interest or not, so just let me ask you. I signed an order directing escrow payments, and so, did you file escrow payments?
Oh, I just brought the payment in, now I'm down.
You just did
payment. They brought the payment down to down here to make the payment with, for the 3,000 or something.
Yeah, it was
But-
$3,352.
Yes, that's what I was telling you. And when they got down here to make it the first time, the payment hadn't, I guess you guys' paperwork hadn't made it down there yet. So they brought it back the second night. The payment did get paid, yes.
Okay, and then that was to be paid on the first of the month, okay, and then was that to be continued to pay? It sounds like every month we were supposed to do that.
From what I was told, this was the dismissal because he took possession of the property back.
I see, so you no longer have the property.
That's what.
Okay.
Gotcha.
Okay, well, their motion never made it here, but it is on my docket, so and this would be a motion to dismiss?
Yes, that's what I was.
So, sir, let me just ask you something. When they took the property, did they sell it? Do you know?
From what I'm getting at, from my understanding, the guy who was gonna get the property from me, the owner who got the house from me, he wanted just to have the property, the keys back to the property, and he's selling it to him. So the property is in the process of getting sold.
Okay, were you renting or were you owning? You were owning?
I own it, that never rented, was fixing it up, getting it ready to sell.
Okay, so my question, just very narrow, is if they sell the property for more than you owe, you might be owed some money back.
That's what I was trying to get to, but I don't know.
Okay, so,
I just know he said he wanted that, had the keys to the property in order for the deal to go through.
got it.
And I said, okay, he wanted to take possession.
Okay, did you give him the keys?
He got it he got everything.
Okay, so I can do a couple things. One is, I don't have the motion, he said it. Technically, I can move this and hold them accountable for not showing up.
Yeah, because this is the third time I done showed up and he didn't show.
Right, so, I mean, this is your time and my time, but I could also just dismiss it and have this off your back. The issue I have here would be
If I can.
that you might be owed money, so they should give you some kind of accounting as to what has happened.
Yes.
And so I really don't want to lose jurisdiction to have that accountability for you, sir.
Yeah.
Okay, so.
So, my question is, so if we dismiss it today, that means I'm totally, it's they ball game?
It's done, it's all done, it's all closed, but they do have a responsibility, I believe.
Yeah.
And what I see in many cases and what I order is if they receive more money than is owed, then you're entitled to that.
Because I know for a fact it's gonna be more than what he got it for, but.
So that could be a post-judgment matter. I mean, we could draft an order that says that you showed that they did not.
Yeah.
And that, they will provide an accounting to this court and that you will be paid any monies, if any are in excess.
Yes, that'll be okay with me, because like I said, I'm like you, I was at, like I said, Zoom you had twice, but I see you was busy and you couldn't get to me. And then now I show
Were
up
they
here.
here? I don't think they were here either. Right?
I don't,
Yeah. Okay, well, they said this, so.
the only reason I know he sent me a picture shot with your name on it, with your courtroom today for 11:30, say to be here. So,
Well, that's at 11:30. It's now 12:19.
yes,
So, do we have I don't have a new address for you. What's your new address?
1328 Foxfire Street.
Foxfire?
Yes, Street, East Lansing, Michigan, 48823.
Okay. So we're gonna draft an order that says that this matter that the hearing was held, that defendant showed, that plaintiff did not show that this matter is, closed. However, any monies as a result of the sheriff's sale that are in excess to what is owed shall be returned to you, Mr. Parker, and that the court and you will have an accounting of those funds for verification of what did or did not happen.
Yes,
Is that
ma'am.
acceptable?
Yes, ma'am.
And then, because they weren't here, and I don't know why they're not here, especially if they gave you the notice, I'll give both sides an opportunity at 21 days to appeal this order. I don't know what else to do unless we just set it again, because we've been here 3 times. There's nothing to keep this open. You don't have the property anymore. And also the order should change the caption to have her name on it. So we'll get all that cleared up.
Okay.
Okay?
Yes,
So
ma'am.
you should see the order in a couple of days.
Thank you, ma'am. You guys be blessed. God bless.
Thank you. Good luck to you, sir. Got that?
Yep,
Okay.
I wrote it down.
Nancy's got that. All right.
All right, that's all. Hey Samantha, what case are you here for? Samantha, what case are you here for? Hey, you're muted if you're trying to talk.
When did that start, do you know?
No, she says they're working out, when her last day is gonna be.
Get that recording again.
Council?
Yes, we're gonna start on with Daniel Trevino, Your Honor.
Grab it from Nicole. That's okay. They're grabbing my file, but in the meanwhile, this is people of the state of Michigan versus Daniel Trevino. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
You got Fred Blanchard on behalf of Mr. Trevino. He's standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And sir, are you taking any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no.
Have you had an opportunity to speak with Mr. Blackman about sentencing?
Yes, Your Honor.
And have you read the pre-sentence investigation report?
Yes, Your Honor.
All right, thank you. On behalf of the people, any corrections, additions, deletions?
The only thing, Your Honor, when looking at the victim impact statement on page 3, it talks about the cost that Meridian Township had submitted, the $714.19. It's not written in there, but I also believe we should write that the cost of prosecution is $125 for an OWI guilty plea. And that would be requested as part of restitution as well.
There's a couple of different page 3, so.
Sorry, page 3 of the report.
Of the recommendations, okay, so. $714.19, that was for.
That's for Meridian Township.
Meridian Township, it really should say who it goes to.
And then it would be $125 for the Ingham County Prosecutor's Office for cost of prosecution.
Okay,
And then I have no other changes to the body or the guidelines, Your Honor.
do you have any changes, corrections?
Nothing, Judge, everything's correct.
All right, you, okay. Sir, you pled guilty to count 1, operating while intoxicated, impaired, controlled substance, 3rd offense, punishable by 5 years. Do you recall that?
Yes, Your Honor.
All right, thank you. And on behalf of the people, what's your recommendation?
Yes, Your Honor. Given this being Mr. Trevino's 3rd OWI offense, I do believe that the recommendation of probation is appropriate of 18 months, 30 days jail with credit for 2 days served, 480 hours of community service, and a 90-day scram tether upon release. Thank you.
All right. Counsel, what would you like me to know?
Judge, I've known the Trevino family for a long time too, and I've got to know Danny. And I've represented him in the past, and like yesterday, day before yesterday with Mr. Ray, that's like Danny's he knows that he's got to stop it. He's on a different, hopefully on a different path at this particular time. Right now, Judge, because of this particular offense, he lost his other job. He's been actively looking for a new job. Right now, he's got a call out, and they're supposed to call him back today. I had heard from Danny about being a maintenance person at one of the hotels or motels in Lansing. And I'm assuming he's gonna be able to do that. What's happened with him is he's involved in AA now, and he will talk to you about AA. He's got his coin today here, Judge, so he's doing the right thing. Judge, they recommended, and he and I have been looking in, because I know what's Skyward Recovery was one of the recommendations in the assessment. He believes he needs to get involved in that, and he's going to do that. He's gonna tell you he's been sober. He was using, I get them all mixed up sometimes, Judge, when you have an alcohol tether, but when you have the one thing that you blow in,
Yeah, I always just call it the blow and go.
the
Yeah.
blow and go thing, I mean, that's a chore, and he had been doing that also. He's done everything I've asked him to do. He knows that because of where he's at right now, that alcohol's a problem. And if he continues in this, like I talked about 2 days ago, he's either gonna be dead, or he's gonna kill somebody, or he's gonna be in prison. And he knows it. And I know his family, and I've talked to his family about that. I think he'll do the right thing, Judge. What we're asking at this particular time is, because he's looking for employment, we're asking the court, if the court will consider, there's a minimum 30 days, which would be if he has 2 days credit, but with 30 days, he gets 5 off. So he's probably got to do another 23 days, if that's what the court sentences him to today. What we're asking is that the court would consider possibly weekends. So during the week, he can be looking for employment. If he doesn't get that, he's going to have to pay a lot of money for fines and costs over the period of probation, but he's reliable. He had a machine.
My battery to my e-bike.
His e-bike, because he's not driving, but he's got this big battery, his e-bike. That's the first time I've ever seen one of those today. But he's doing the right thing, Judge, and he'd ask the court to sentence him accordingly at this particular time. Thank you very much.
So I have a question. The high school narrative says that you basically dropped out in 9th grade, but you went to Lansing Community College and you have a year of engineering. Is that correct?
Yes, Your Honor.
So when did you graduate from high school?
I never graduated. I dropped out about almost end of 9th grade.
Okay, but then did you go to the Lansing Community College program where you get high school and college at the same time?
No, I never did the high school. I paid out of pocket for my classes.
I guess what she's asking, how can you go for an engineering if you don't have a high school degree?
I don't know. I didn't have a high school degree, but they let me attend the classes.
So did you do more, was that more of a trade school? I mean, if you're in engineering.
I went to the, not the campus downtown, but the campus kind of over by Myers Warehouse and stuff.
Yeah.
That's where I went to
It's like an
attend
extended campus. I'm familiar with that, but it's still, you get college credits. I'm a little confused on that. So what do you want to do with your life, sir?
At a time when I was younger, I kind of wanted to go into automotives. But things are going a little bit more electrical. So I decided to kind of shift into, my goal is to buy and sell houses.
Is to what?
Buy and sell houses?
Yes.
So you're gonna get a real estate license or what?
I was looking into the real estate, because I gotta pass the test. But more right now, I'm just kind of focusing on,
Flipping houses, you wanna flip houses?
I wanna buy, foreclosed homes and then fix them up and resell them.
So you wanna flip homes?
Yes.
Do the resources to do that?
Right now, I'm just kind of starting off at the basis. I had a little, pile of money saved for the foreclosed homes, because you can't really get a loan on it. You have to pay out cash.
Right.
So I was saving up to start off with a cheap, like $15,000 house and kind of work from there.
What about getting your degree?
Say that again.
What about your degree?
For the automotives, I decided not to go for it. I was possibly thinking about going back for either plumbing or electrical.
Oh, what about your GED?
At the same time, there's a place, I forget the name, my kid's mother told me about it, where you can get a free GED. So I was getting the information from her about looking into that as well.
Okay, well, probation will help you. Okay, so there's a program at LCC. It's the Reconnect program. I don't know if you qualify for that or not, but at LCC, you can get college and a GED at the same time. So you can get that electrical engineering or business degree or whatever for what you want to do. get it all at the same time.
Okay, I'll look into that.
Why did you drop out of ninth grade?
At the time, schooling's never really been for me. I'm more of like a competitive person to get it stuck kind of in my head.
Did you have a learning issue or?
I used to have special ed classes when I was younger in elementary. When I moved to middle school, I didn't really have the
Okay.
special ed classes, and I never really kind of further asked about it, so.
Okay. Because there are lots of programs that can help you and that you would qualify for if you need help, and then, you know, people cannot take away your good name, they cannot take away your education. That's your insurance policy for your future. So, especially if you want to flip houses or get into real estate, you want to get into these money things, people are gonna look to see what kind of man you are, what kind of education you have, so you might want to look at your education.
That's right.
Okay, and if it's tough for you to get, there is help, and if you can't do that, then that's fine, there's trade school and other things, but with what you wanna do, you should get some qualifications and some skills, otherwise you're gonna not make any money, because you're gonna have to pay big bucks for people to pick up the houses you get for cheap, and you're not gonna make money, you're gonna lose money.
Yeah, I know there's a lot to it.
There is. And so even assessing the home, whether the electrical's good or any of that, and, you know, when you buy those foreclosures, there's not the kind of appraisals and all that, you know.
It's a 50-50, you gotta know what you're looking for.
Yeah. You might buy a money pit.
Yeah.
So I would think some education would help you, and that's why I'm asking, but also I think when I see people drink away their life, I have to wonder what you're suppressing and how you feel about yourself. So I think that staying busy, building up yourself, especially with education and employment, is a good thing. Why did you turn to alcohol, do you know?
It was just something that usually young age, everybody kind of experiments with some things. I like alcohol pretty much the first time I drank it, and kind of been battling with it since.
So you didn't just experiment, you went the whole 9 years and then some.
Yeah, and I took it overboard for sure. I know, realizing now that I can admit I have a problem. I want to do something about it, you know, because it's 1 year from being 30 and kind of got a lot of hurdles to go through, so.
So your 29 years have gone pretty quickly, haven't they?
Yeah.
Want to know how fast the next 50 or 60 years is going to go?
Pretty quick, blink of an eye.
Exactly. So you are running out of time to get your career on the path, get a retirement, make sure you have social security and savings and a 401k and all those things that you deserve. You're only standing in your way. You spent all that money and time on alcohol. It got you nowhere except in front of me.
Sure.
You're lucky you're not in a body bag and you didn't take someone with you.
That's right.
Judge, the other thing too is, he wanted to tell you, but he also has a sponsor at AA now.
Oh, good. So what else would you like me to know, sir?
I've been going to AA pretty faithfully. I got a sponsor now. I'm working on the steps. I'm transitioning from powerless to finding a greater power. You know, I realized I do got an issue. Back then I tried to justify it or find a reasoning. The real reasoning is just I got an addiction and I'm ready to do something about it, get my life back together. Like I said, I'm about to be 30 years old and kind of starting back over. So I got a lot to make up for, a lot to prove myself to be able to get my life back in order.
So you have 3 children.
Oh, yeah, sure.
Huh?
Yeah, sure.
And you see 2 of them?
Yeah, sure. I get them every weekend.
But not one of them, Rosalina?
No, Your Honor.
Why not?
Me and her mother never really got along too well. She ended up getting married to her husband. In that time, he never liked me, so she just figured it'd be easier just to.
What about you? What did you figure?
I don't agree with it.
How do we know that?
What do you mean, Your Honor?
How do we know you don't agree with it? Let me just tell you something. You have a constitutionally protected right to raise your children. Constitution stands with you if you want to be a parent. I don't care what she says, and I don't care what her husband says. Her husband has no say. You go to the family court and you request parenting time. And how long has it been since you've seen her?
It's possibly going on about 2 years. I've tried to get the paperwork.
How have you tried? Is there a petition pending?
No, well, I got the packet. I've filled some of it out, but there's some I don't understand. And then I went to go try to get a lawyer to help me out with it, but they said I would have to.
What don't you understand, sir? You're the father, you know your address, are you on the birth certificate?
Yes.
Okay, that's all you need.
There was just a few things to the pack I
Like
didn't
what?
quite understand. It's been a while since I.
Probably your income, where you live, everything you know, if you don't know, leave it blank, the judge in front of the court will ask you. All you do is file a petition, it costs you 20 or 30 bucks, or I don't know, 130 or whatever the filing fee is these days. But here's the problem that you're gonna, are you paying support on her?
Yes,
Maybe you don't want to see her?
I do want to see her. I
Let's
just.
prove it. Here's the problem that you have. You have an 8-year-old daughter who thinks her dad doesn't like her or want her. You have let another man stand in your shoes. And she thinks you've forgotten about her. Fix the problem, because pretty soon she's gonna be an angry teenager and you'll never repair the relationship. And blaming her mother, the woman who raised her, is not gonna work well.
That's right.
Judge, if I might, yeah, this is the first time I've really heard about it. I don't do that area, but if I'm gonna tell him, come in, let me help you do that.
See that? Probably take Mr. Blackman about 5 minutes to get that form filled out. You go downstairs, you can even get the form downstairs, fill it out. For the court's right there, set it for hearing. You might start out with supervised parenting time, especially with this file here. But eventually you should have unsupervised, and all your rights should be intact. You sat on your rights to be a dad. And the thing is, at some point, she may very well say, terminate your rights because I want my husband to adopt her. How do you feel about that?
That's a good girl.
Well, step up to the plate.
That's right.
She has no right to cut you out. I could cut you out. And if you are drinking, I will not let you see any of your children.
That's right.
It's one of the reasons I'm having this conversation with you. You want to see your children stay in their lives, you will stay sober and clean.
That's right. I understand.
So what else have you done?
I've been looking for employment. I was thinking of possibly maybe start my own business of doing like small contracting jobs. Right now I've been kind of doing gardens, fireplaces. I've done like a catio for outside for somebody. So I've been trying to take slow steps and trying to find employment, stay busy.
Well, make sure when you're taking on those jobs, it's not interfering with the law in terms of you doing a job that takes somebody licensed. So be very careful.
That's right.
So you've been attending AA how often?
Once or twice a week, depending on how often I can get a ride.
And what step are you working in?
I'm transitioning from step 1 powerless to step 2 integrator power.
And do you know that there are some meetings on Zoom that you can attend? So if you can't go there in person, you can get online.
Yeah, I've heard of some. I like to try to,
In person is much better,
Yeah.
but you know what, if you need that consistency, you need that reminder, it's good to just get on Zoom and do them.
What he's done, he's gotten up, these are all the meetings, and
Oh,
so
great.
he's, what he's trying to do that also. Yeah.
So tell me the status of your vehicle, what happened to your vehicle?
it got totaled in Mount
Okay, so that you no longer have that.
No, Your Honor. Right now I got a e-bike for transportation.
Okay. So you're gonna be on probation for 12 months. If you do well and everything's going well, that'll be fine. Otherwise, I'll increase you up to the 36 months.
Yes, Your Honor.
And I normally do at least 24 months, if not more, but you're already doing what you should be doing, so you're way ahead of many people who just sit and do nothing until I tell them to do it. So I'm encouraged by that. You shall not use, possess, consume, purchase, or be in the presence of alcohol, or illegal drugs, or paraphernalia. If you have the need for any of those things, that includes alcohol or marijuana, you will present a prescription from a licensed medical physician within 24 hours and use it only as prescribed. You can use over-the-counter medication as labeled on the bottle. You can use less, but not more. You will pay for the cost of your substance abuse testing and treatment. As to testing, if there is a positive, you will have a secondary test done to make sure it's a real positive and not a false positive. You will attend AA, NA, or CA no less than 1 time per week. You will maintain a sponsor who has at least years of sobriety and who has gotten that way through a program. If you are, have you had a substance abuse assessment?
Yes, Judge, that was part of the thing. There is one in the court file.
Okay, thank you. So you'll follow the recommendations there, and that would include relapse prevention and any aftercare. Are you on a string tether? Or a,
No.
Okay, if you're positive, you'll immediately be placed on a scram tether.
Yes, Your Honor.
You will perform 60 days of community service as directed by probation. You will obey all court orders, recommendations from all treatment providers and physicians. Those become orders of this court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have written, verbal, electronic, or physical contact with anyone housed in Michigan Department of Corrections or who is on probation or parole. If you need to have contact with them, maybe you work with someone on probation or parole, that's fine. Just let us know. As long as everybody's in good standing, then you will not be allowed to have that contact. You will contact probation today, make and keep all appointments. It's best once you're in this building, just go downstairs and make the appointment. And then keep all appointments. If you need to miss an appointment or change your appointment, that's on you to chase probation. They don't chase you. You'll also comply with all written verbal and written orders of probation. Those become orders of this court, and allow probation into your residence at any time for probation supervision without a warrant, and submit to a search of your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection, or placed on you, loss of employment, or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. You will be part of a work seek program, and you will work with your probation agent to figure out if you want to do the GED LCC program, trade school, but with your goals, I want you to do some kind of trade school or continued education, because otherwise, sir, if you're gonna do this work and you're unlicensed, it could be a problem. So we don't need any more problems, and there's areas it seems that you like. So figure out if you need a license or not, and then there are a lot of trade schools and all sorts of things around that you could get involved with and then get a good job with the benefits and all that. and then open up your own business or side business or whatever it is you want. Well, let's have a plan. You're 29, you need a plan.
Sure.
What you wish is not a plan. Let's get to where you need to be with a plan, and probation is there to help you. Probation might seem like a punishment to you, but jail or prison is a punishment. Probation is there to help you succeed. You will not drive a motor vehicle pursuant to the statute unless you first obtain written permission from probation and Secretary of State. In accordance with that, your license is revoked, and if you haven't received notice already, which I suspect you received it after the plea, it is revoked in accordance with their rules, and then how you get it back, you can talk to counsel about. You will serve 365 days jail with credit for 2 days served. The balance is held, however, you must do 30 days jail pursuant to the statute. So how do you have your parenting time with your other children?
I usually get them every Friday, about 5 o'clock, and then
Okay.
until Sunday, about the same time, 5 o'clock, 6 o'clock.
So you want to do your jail time Sunday night to Tuesday, or do you want to do it like every other weekend, or what?
Sunday to Tuesday would be fine, Your Honor.
What time do the children get picked up?
Between 5 and 6, usually every Sunday.
Okay. Sunday by 8 p.m. we will report to the Ingham County Jail. And then you will be released 48 hours after that. Because the statute says that at least 48 hours are served consecutively, so you have to do it in 48-hour blocks until the 30 hours is done. So it'll be Sunday to Tuesday. That's 2 nights. 48 hours, okay? And once you are employed, okay, let's say you get a job where, I don't know, you get out at 5 o'clock or something, or let's say you get out at 10, you have an hour to report till 11, but we won't worry about that till you get employed. So these 30, you have 28 days, so you up for 2 weeks, right?
With good time probably.
Yeah. So they'll figure it out. And if you want to do some more, if you want to do like a couple weeks in a row and get it over with, that's fine, but you do no less than the 48 hours.
I'm asking for the moon, but he had told me he's gonna have his children over the 4th of July next weekend for the 4th. Now, the court denies that that's fine, but he had asked me if the court could.
Well, the 4th is
Oh, matter of fact, the 4th is a
Saturday.
Sunday. It's a Sunday, right?
Saturday.
It's a Saturday, so
Saturday, so
he goes,
we're
so
okay.
he can spend that
What's-
with them, so.
So you'll be fine Friday,
Yes,
Saturday,
yes,
Sunday, you just have to, so what's the time period you have them over the 4th? Is it Saturday and Sunday?
I usually get them from Friday 5 and then drop them off Sunday around 5, 6.
So we're okay for that?
So we're good. I apologize.
That's okay. So we'll do that, and then, there's no vehicle immobilization since your car was totaled, you'll get $714 reimbursement to Meridian Township. Law enforcement. And $125 to the Ingham County Prosecutor's Office, both of those are cost recovery. You'll pay that to the court, and we'll forward it.
You what?
You'll pay that to the court, and we will forward the money, and we'll keep track of it. You'll pay a $68 state cost, and $130 crime victims. You're not working now, so I am going to waive probation oversight fees because you are indigent for that purpose. Will not use any object as a weapon, no guns, ammunition, imitation of a weapon. I'm only going to place you on the MDOC scram if you're positive. And as part of your treatment, you should be engaging in cognitive behavioral, which I think they all include now. You have 42 days to appeal and to request appellate counsel. Is there anything I have missed?
No, yeah, I have also handed in his appeal right.
Great. So you have two things to do downstairs. First of all, do you acknowledge your appellate rights?
Yes, sure.
You're gonna make your appointment with probation, you're gonna go to the front of the court and get those forms. You gotta fill out.
And I'll
If you
help
wanna
her with
be
that,
there.
Judge.
Yes, sure.
Otherwise, you're just a sponge.
Yes, sure.
Be the dad that your kids need, including the daughter you haven't seen for 2 years, you got a lot to make up.
Yes, sure.
Thank you. That's all.
Thank you very much, Judge.
Thank you, Aaron.
docket 256826FH, people of the state of Michigan versus Jeremy Michael Barber. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, I'm Dwayne Sullivan from the Office of Public Defender on behalf of Jeremy Michael Barber, who is standing to my right at the podium.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there medication you're supposed to be on that you're not on?
No, I'm supposed to be on it all.
Okay. Any sign of fever, COVID, or other illness?
No.
All right. Have you read the pre-sentence investigation report?
Yes.
Thank you. And you pled guilty to possession of a controlled substance known as cocaine less than 25 grams, punishable by 4 years. Sure call that?
Yes.
All right, thank you. On behalf of the people, corrections, additions, solutions.
Yes, Your Honor. In the PSI, the original sentencing date is 5/27, so that needs to be changed to today's date.
And that'll have to be throughout, give me a moment.
Correct.
I'll do that. So it's on the cover page. Basic information sheet.
And it will also be on the evaluation plan, Your Honor, at the bottom of the first paragraph. Then finally on page 11 in the criminal history.
Yeah, instant offense. 13 of 13. And then that's all I see. Anything else?
Yes, Your Honor. Attorney Frank Harrison was part of the PD's office and was on this case at the time of plea. However, Attorney Silverthorne is taking over for sentencing, so I believe it'd be appropriate to make that distinction in the report.
I would change on the cover page. I am changing it, let's see, under evaluation plan. And then the basic information sheet as well. And then, in regard to counsel, Mr. Harrison was retained, but Mr. Silverthorne, you're appointed?
Both were appointed, Your Honor.
Both.
Both were, okay, so let me make that correction as well. So I've done that on the basic information sheet, and I'm doing that on the cover page as well. And then,
It's also the evaluation plan. Your
yeah,
Honor.
you can change there. Okay. Any other corrections?
One final one, Your Honor. When looking at the defendant's criminal history on page 8, number 6 of 13, it states that count 1 that the defendant pled to was failure to stop at a personal injury accident. It says it's labeled as a person felony level E. However, Your Honor, that's actually a misdemeanor. So I think it'd be appropriate to mark that as a misdemeanor. And then count 2, where it states operating while licensed, suspended, causing injury, that is a felony, that is a person offense level E. So I believe those changes should be made.
Any objections?
No, Your Honor.
Changes have been made.
And I have no other changes to the guideline, to the report, Your Honor.
Thank you. Mr. Silverthorne?
Yes, and they're very few. Under the evaluation plan, the third paragraph down from that. Next to the last line in that third paragraph, where it reads, the ability to help his ex-mother-in-law, the ability to help his mother-in-law.
Make that correction.
We're going to then jump ahead to further report under the box section, I call them, under family. That would be on page 12.
Yes.
His father's name was Francis Meg, not Franny.
Okay.
And his mother now lives in Lansing, not St. John's. And the last one would be on the basic information report.
Okay.
His last known address and telephone number would be 4105 Mar Moore Drive. That's 3 words. Lansing, Michigan, 48917. His telephone number remains the same.
Okay. Any further?
That's it, yeah.
How about guidelines?
Yes, Your Honor. PRV 2 are prior felony convictions. As I had stated, for number 9 of the criminal, or number 6 of his criminal history, probation had labeled both count 1 and count 2 as felonies, when only count 2 was a felony, which would bring the PRV 2 down to 10 points.
PRV 2 is 10, I take it there's no objection.
No objection.
So is that the only change, so it's 11
That is
total?
That is the only change, so yes, PRVs would be 75, that would not change the guidelines or the level.
Let me change basic information sheet. And then let me see if it's under the narrative. It's not in the narrative, so we're good, I think. Okay. Mr. Sullivan, are you doing any additions?
Yes.
Do you?
I'm sorry?
Did you have any additions to the?
Oh, no, I
guidelines? All right, thank you. On behalf of the people, what would you like me to know?
Yes, Your Honor, the people are concerned with Mr. Barber's criminal history, especially considering that a lot of it seems to be substance abuse related. Other concern that people have, Your Honor, is the fact that with his history having as many felonies as he does, as many misdemeanors as he does, the people are just concerned and are unsure how much probation would be able to help Mr. Barber at this point in time. So the people would be in agreement with the recommendation of 365 days with credit for 2. Thank you.
Mr. Silverthorne?
Yes, Your Honor. Let's go to the criminal history. And I have to apologize in advance. I've come very late in this case. So luckily I think I'm a quick study. But I think what's significant is I know that he has an extensive history, but I also know that the extensive history, the worst stuff occurred over 2 decades ago, over 20 years ago. In 2005, he went to prison for about 5 years. He said he got released at very early 2011. So for the last 15 years of his life, he's had a driving license suspended, a retail fraud in Lansing that was dismissed, another retail fraud, second, in Lansing in 2019, retail fraud third, that was in Eaton County, resisting an improper use of vehicle in 2022. And then he had a controlled substance case in Eaton County in 2022. I noted that on that is 12 of 13. So I asked him about that. And it says 24-month adult drug court probation. And he asked if he was successful, and also that I could look up, and the clerk could look up if he wasn't. And he said he was successful. I note that he noted when he self-reported in terms of the substance abuse history on the opiates, he went for how long, from 1994 to 2022. That would coincide with this 2022 plea and conviction in Eaton County. So he was on 2 years successfully. Then he said this. So the last 15 years, he's done pretty well, or they've been retail fraud or driving license suspended. They haven't been the charges that he had earlier. I would note that currently, although he's not a requirement of bond, and he's certainly not on probation, he's a volunteer for Lansing Serenity Exchange that helps with homeless and drug use. And I asked him what he does. And he indicates that they have a building. They're located at homes of Martin Luther King, and he's worked for them for the last 3 years. He takes toiletries, clean clothes, clean needles, anything that he's basically a delivery person helping these people that, like him, have a drug history. Additionally, while he's doing that, he has, the court would note in his family, most of his kids are grown, but he does have 2 young boys that are 11 and 12. He has 1/2 custody of them, where half the time they're with him, half the time with their mother. She supports them when she has them. He supports them when he has them. That is commendatory. He's currently still involved with community mental health. In fact, the drugs that are listed in terms of his numerous medications are all prescribed by community mental health, with which he maintains very, very frequent contact. And I'd also note that the amount of cocaine came back, because there's always the concern, are you out selling? It was 2.545 grams, which is without anything else, like scales or large money, suggests use. Although he indicates that although he thought about using, he didn't, but he was in possession, and that's what he pled to, because he was guilty of that. And I explained to him, I said, one of the things about alcoholism or drug addiction is not necessarily getting rid of the want to do it. You may always want to drink. You may always want to relieve your pain. But the mark of a successful rehabilitation is not doing it, despite wanting to do it. Because the wanting may never go away, but you have to learn how to cope. And he seemed to adopt that and understand that. As I said, he's currently, in addition to the other things I said that he's doing, he's currently in AA and NA. He's at the AA Club West. I asked him if he still attended. He said he did. I noted in the substance abuse treatment on page 14, the end date is that he's currently doing it. He's currently doing outpatient with CMH relapse prevention. That's current. That's how he's able to get medications for his multiple diagnosis. So this man is doing what he's supposed to do. If the court looked at his early life history, it was horrific. He did not have parents. He had, I think the court used, with the last sentencing, the term sperm donor. He had a couple of sperm donors. He and his sister had a couple of sperm donors. And finally, at 47, it looks like he's getting it. I don't think he needs incarceration, and I think he would do wonderful on probation, and particularly have him continue the work he's doing with the Lansing Serenity Exchange, because out there, he's actually helping other persons, and he has credibility with them because he was of them for so long. So with this, Your Honor, I wish I could say more, but this is what I was able to glean in the time that I had, and I invite the court to question Mr. Barber.
Sir, what would you like me to know?
I'd like to let you know that, I have made a lot of mistakes in my lifetime. And I have, through the time of going through drug court with Eaton County, I realized I'm getting too old for it. that this isn't a life for me. I still got 2 young children that I got week on, week off. And then I want to be there for the lives instead of dead in the grave or incarcerated like I was for some of my other children, which are here to support me today. One of my oldest, you know. I have a lot to live for. I have 3 grandchildren with my son that love me dearly and that love seeing me and support with me. And just, I know I've made mistakes and I made a mistake this time and I'm willing to own up and take the responsibility for it. But it was a mistake that I wish I would have never made and I'm working on not doing that. Since then, I had moved in with my mother-in-law, which is a peer recovery coach. So she's constantly on my head every day, and she's helped me get so far with CMH for my bipolar medications, which I was off at the time of. My thoughts just wanted to go back to using because I thought that would help me with my meds instead of taking my meds. So currently I am on my meds and they have got me on a new one, so it's a shot once a month for my Abilify. So I'm getting my proper meds and the proper medication I need in treatment. I see my peer recovery, or not my peer recovery coach, I see my case manager twice a month, and I see my psychiatrist once a month for my CMH to just continue to stay on the right track so I can be alive and be with my children and my grandchildren instead of in the grave or incarcerated. I'm trying not to be a deadbeat that I was when I was a kid. And I've come to realize that I'm way too old for it, and I don't have much life left to just be wasting and throwing away on stupidity things.
Before I respond, I was looking at your marriage here. I have some questions if council wants to turn to page 13. It says Melissa Barber is your wife, and then it also says Melissa Barber is your wife, but it also underneath that says she's your former significant other. I'm assuming you're not married to twins.
No, no.
They have the same address and how they wrote it is weird.
She's my current divorce from my first wife. She's my first wife.
So she's your former wife?
Yes.
Okay, so I'm just going to put ex-wife. So that needs to be cleaned up. And then they have Travis as your stepson being 29 years old, but a third grade student at Atwood Elementary. I take it he's not third grade.
No, he is not. No,
So
he
I'm
is not.
striking that. Then I have your Tyler, your son who's 26, being a kindergartner at Atwood.
No, I don't think so. He's here in the program with.
Okay, just making sure they, whatever, they got that really wrong, because I started going, what was wrong with this picture? Okay. And so hopefully they got the rest right.
I believe so, and I have to express embarrassment
No,
that something so obvious escaped my view.
And so is your significant other Lindsay?
Yes, she is.
So you're still with her?
Yes, I am.
And is she your significant other or wife?
My significant other.
Okay.
We haven't got married yet. We were actually planning on coming down here to make a date to get married.
Okay, well, I perform weddings. Anyway, aside from that, is her mother the one that you're calling your mother-in-law?
Yes, yes, it is.
Okay,
She's been there.
she's not yet your mother-in-law, but she will be.
No, not yet, but she treats me as her son-in-law, so.
I got it, but I just want to understand this very weird thing they put together here in the relationships. Okay. Okay. We have a history here, sir, that really does speak to an addict. When I look at this is all from it. So I think I saw somewhere in here you did go to residential
This I did for 90 days, Your Honor.
and how did you do there overall?
I did very well there. I actually took in a lot and learned a lot there from it. Something that I could have wished I got sooner, my addiction and what I did. I feel it's helped me a lot. That's actually what keeps me pushing to go into the L&R Club West 2 to 3 times a week, just because, especially on Saturdays on guest speaker meetings, I like to be a guest speaker because I like to explain to from where I was from and where I'm at today. Because I feel I've made a big step towards the right direction, and I feel other people need to hear that too, so they can learn how to do that.
Well, I
There's-
appreciate you want to help people, but you gotta help yourself first, sir. Again, council, where it says on page 14, Sheriff McComb is where he went inpatient, they spelled Detroit wrong, so I just corrected that as well. Okay. Here's what we're gonna do, sir. Recommendation is for a year in jail. I'm gonna give you a chance for probation. But here's how we're gonna handle it. If you have a dirty drop, don't wait for me to get in front of me, work with probation and go residential again.
Okay.
Because when I look at this and all these problems, I don't know if jail's gonna be it. I might very well send you to prison. Cocaine is killing our kids, and you have young children. You have adult children, so do I, but I have young children too, and so do you. They don't need access to cocaine. They don't need people using it. The more you use it, the more the people who sell it make money, and the more they want to sell because people are there to purchase it.
Right.
Someone's gonna be in some school corner offering it to your children. How do you feel about that?
I can't answer that question, Your Honor.
You can't answer how you feel about that?
Oh, how I feel about it, I would want to kill somebody about that. That would really destruct me.
Well, but you're part of the problem, sir.
I understand that completely.
So you have got to stop and be the example of stopping, and that you can make a mistake, but that you can learn from it and do better. So it's okay to want to help the homeless and do all the things that you're doing,
I gotta help
but
myself.
you have to help yourself first, and I'm not sure you're on solid enough ground to help others. Okay? I'm not telling you to stop helping others, but your focus has to be on you, because if you don't do well, I've told you, my goal is rehabilitation, and it will start with residential treatment. If you don't do well there, I mean, we'll likely think about prison because of the record here, because you will not have taken this seriously, because I'm giving you the gift of probation. Jail is a punishment, prison is a punishment, probation is a gift. You either use it or you throw it away. You throw it away, I will not let you kill yourself or someone else. It will be prison. Understand?
Yes, sir.
And I'm not talking about something small, and then maybe I'll send you to jail for a reminder. But understand, the way I see addicts, it's kind of like that saying, you go big or you go home. They go big. You go big, you go prison.
Right.
Got it?
Yeah.
So you're gonna be on probation for 18 months. I can increase that up to 3 years or 5 years. I can also send you to jail or prison. I think I've been clear about that. You will be tested right now until I make sure that you are not using. You will be tested Monday, Wednesday, Friday, and random on the weekends, and then probation can reduce that. Now, I have done it like that instead of you calling every day, so that you can figure out a reasonable work schedule, so you know what the schedule is. And then probation can reduce it further. If you are using under this schedule, we will figure it out very quickly. And then you will immediately be placed in a long-term, which is not less than 90-day residential treatment program that is geared for cocaine. And then you'll follow all the requirements there, including all aftercare. You will serve 365 days jail with credit for 2 days served. The balance is held. I told you how we're gonna handle this.
Right.
So you have the keys to your life and to the jail and to the prison. Decide. You will pay crime victims assessment in the amount of $130 and a $68 state cost. I'm waiving probation oversight, fines and other costs because I'm finding that you are indigent. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have a need for any of that, you will provide a prescription from a licensed medical physician within 24 hours. Any psychotropic meds, and I understand that there are some issues there. You will take all psychotropic medications as prescribed and not change the dose or stop taking it unless you're working with your treatment provider, because there's a lot of options and sometimes those meds change depending on how you feel. I suspect your whole life you were self-medicating. Now that you're on medication, working with CMH, you're doing all the things you're doing, hopefully you don't need the illegal drugs. We can also test you for the levels of any psychotropic medication to make sure that you are taking the appropriate medication. You will attend AA, NA, or CA as required by probation. Are you doing that now?
Yes, I am.
How often?
2 to 3 times a week.
Okay, no less than twice per week, and you will maintain a sponsor who has gotten clean and sober through a program and has been clean and sober at least a minimum of 5 years. Have you completed a relapse prevention program?
I think so.
Okay, well, if you have not completed a relapse prevention program, then you will, and you can do that through CMH or whoever you're dealing with now. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections who's on probation or parole. If you end up needing to have contact with those people, you'll let probation know, as long as everybody's in good standing, we'll give you permission. All right? They'll contact probation today and make and keep all appointments. You'll comply with all written and verbal orders of probation, any treatment providers, those are from orders of this court. You must submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer. If there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest, police contact, personal protection order, loss of employment, or change of residence to probation within 24 hours. Weekends and holidays are accepted. So something happens on Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will notify us of any change of address, employment, all of that. And if you need additional employment, I understand you've got jobs, you line those up. But if you need additional employment, you can be part of a work seek program. So if you can't support yourself, you will be part of a work seek program. So I want to see some regular income.
You want to see some what?
Regular income. You will not use any object as a weapon. You'll not own, use, have under your possession or control any weapon, imitation of a weapon, ammunition. You'll not use any object as a weapon. As part of your treatment, you will continue with the aftercare that should include cognitive behavioral treatment. And if you have a positive drop, as I said, you will, that's for illegal substances. You'll have that secondary test that you'll pay for. And if that is a positive, your parenting time will be suspended until we figure out a supervisor. Do you have a driver's license?
No.
Is there anything I've missed? On behalf of the people?
No, Your Honor, thank you.
I don't believe so, Your Honor, no.
Oh, sir, you'll also sign all necessary releases so we can verify that you're doing what you need to do. We don't ask your therapist, counselor, or anybody else. You know, we don't violate HIPAA. We just want to know, are you showing up on time? You're doing what you're supposed to do. Are you participating? Okay. I anticipate you'll do very well. I told you what the consequences are if you don't do well, so I hope that motivates you to continue on a path of healing and sobriety and choosing yourself and family first. You have 42 days to appeal to request appellate counsel.
For the record, I'm now handing notice of right to appellate review and request for appointment of attorney. You acknowledge receipt of this form? Thank you.
And that was, I told you the jail time is the balance is held is 365 credit for 2. Just to make sure we've got that, but it's held, and then we'll see what happens. Good luck to you, sir. I don't have to use any. I look forward to signing your release successfully from probation. You have a lot to lose if you don't do well. Ask for help. It's a sign of strength. Thank you. Next matter.
Yes, Your Honor, we're gonna do Tyrone Howell next.
No. Yeah. But. Working on closing down all my accounts now, getting her pulled off insurance and.
Oh, she tried to.
She'll be in short, she just to take one of the kids to the restaurant.
Okay,
But I think we can begin.
we begin. All right. This is docket 25-5332 FH, People's State of Michigan versus Devontae. I'm sorry, Tyrone Devontae Howell. Counsel, your appearance for the record.
It's on the other file as well, Your Honor.
Oh, yes.
Maybe page 2 of the second page.
Let me grab the other file. Well, we're doing the sentencing on the one. Are we doing the sentencing on both?
Yes.
I believe there's one charge, or there's charges on both files.
Yeah, it's sneaky.
5332 and 5593.
Oh, yeah, I'm sorry. You know what? If they put it in the same report, I just didn't read down far enough. And also 25-5593 FH. Counsel, your appearances for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell. Mr. Howell is present, stands to my right. I will. John, can you approach real briefly?
Yes.
Very briefly, very briefly. I just wanted, this is a, we have an alert. I didn't do a correct one. I didn't do it. Yes.
There's a lot.
Yes, I only know. I just want some. I just want some. Very good, that's fine, it's thousand.
Whatever numbers you say need to be fixed, I agree.
Okay. It's just gonna be started.
Here needs an order.
It's a blank order or?
No, this is, sorry.
It's one that was entered that I just need a copy so I can amend it, re-sign it, date it, and then we'll re-enter.
Okay, on how?
Yes.
Which case number?
I think it's on both, and it should have been entered, I believe, in May.
Did it have to do with communications?
Yeah.
Yep, reschedule communications at the jail.
Yep.
Gotcha.
Thank you.
All right.
No problem.
Back on the record. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth and nothing but perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
This same medication I take.
Okay. Does it affect your ability to understand the court or your attorney?
A little bit, but I'm here.
Well, counsel, you had an opportunity to speak with him. I know you had some regular communication with him. Do you believe he's arranged to date, time, and place that we can communicate today or not?
I believe he is, Your Honor. I spoke with him for over half an hour yesterday. I've also had communication with him by Smart Jail, and I spoke with him prior to this hearing this afternoon.
All right, so are you understanding everything today? Feeling okay?
Yes, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you read the pre-sentence investigation report with your attorney?
I have.
Have you had an opportunity to speak with your attorney?
Yes, Your Honor.
All right, and you pled guilty on docket 25-5332 FH to assault with dangerous weapon, also known as felonious assault, punishable by 4 years. And count 3, assault with intent to do great bodily harm, less than murder by strangulation, punishable by 10 years. And then on docket, and that was on docket 25-5593 FH. Additionally, on that file, you pled guilty to the 5-year felony of count 4, domestic violence and or knowingly assaulting a pregnant individual, third offense notice. Do you remember that?
Yes, Your Honor.
All right. And there was a Killebrew for sentencing defendant to a fixed minimum of 36 months to remain concurrent on both files. And when we were here a few days ago, there were allegations of communication that would nullify this. And today is the time set for an evidentiary hearing in regard to those, because people raised those and counsel did not have an opportunity to review all of that. So have you reviewed that now?
I have, Your Honor, and Mr. Howell also had the opportunity to have that information, discovery, there we go, the discovery reviewed with him by my investigator, Rick Vogel, who was here today with me in the audience. And at this time, based on those review, is my understanding from Mr. Howell is that he would be there would be an admission as to that, and he would not be contesting at this time the court, the Killebrew not being followed, or at least understanding that the court does not have to. We could still ask for it to be followed, but we don't understand. He would understand why it would not be. Thank you.
And Your Honor, the defense reached out to me yesterday to inform me of this fact and that I could call off the detective for this afternoon, as we no longer need an evidentiary hearing. But I believe that technically he was arraigned albeit orally, on this being a PHB 3 violation. The people are not seeking to move forward in that vein. We'd like to move past that and simply focus on the sentencing. I believe that.
All right, so we're going to. We are going to simply withdraw the violation allegations and move forward with sentencing. Is that correct?
That would be the people's intention. As I've said before, I don't have that power, only the court does.
Well, if that's what you're asking, so that's what I'm going to do. It seems that there's no objections, so we will proceed simply with sentencing. Are there any corrections, additions, deletions?
There are, Your Honor. First, when it comes to jail credit.
Yes.
This court sentenced the defendant to 93 days contempt of court consecutive to the underlying files.
Yes.
And so I have the date range here, starting from December 17th, 2025.
December, I'm gonna go to that page, December
17th, 2025 through March 20th, 2026.
And that's the 93 days?
Yes, that would not be counted towards the jail credit. That would bring the underlying total for file 25-5332 FH down to 259 days. And then the total for file 25-5593 FH to 254.
I would be in agreement with that, Your Honor. Obviously, I was here with Mr. Howell on those, and I do know that there was a contempt of court sentencing, so thank you.
Thank you. Okay. And any other corrections, additions, deletions, and I'll have to go through and make those changes. So we have a basic information sheet, the jail credit days.
There is one under consecutive sentencing. There should be written in there that there is discretionary consecutive sentencing due to the bond status at the time of the second crime, second case.
And where is that?
Page 4. Where's the bottom?
I simply struck the last sentence under consecutive sentences and amend the first one to read, there is discretionary consecutive sentencing.
Thank you. And then the last correction that people have to the body of the report, it's on page 6 when it comes to his prior history. And it's offense number 3 of 12.
Yes.
For count 3 of that, they have interfering with electronic communications listed as a misdemeanor. That is a low severity felony. We'll get into that for prior record variables once we get to the guidelines, but I think that needs to appropriately reflect that.
Your Honor, I did have the opportunity on Monday to review the lien with Mr. Pfeiffer, and that does reflect it was a felony, and lien is, the court is aware, probably the most accurate we have in terms of looking at background checks. So that I have no basis to object to that. Thank you.
So I'm sorry, this was on 3 of 12?
Yes.
And do you want me on the final charges to put that, or is that?
On the final charges.
Yeah, where it says misdemeanor person?
Yep, it should be low severity felony.
So I struck the misdemeanor person and added that, so we should leave it there.
I have no further changes to the body.
Okay, I'm changing the jail credit days still, so it is the properly reflected. I've done that for cover page, recommendation page. The basic information sheet. And so I think we are okay. Let me look under recommendation here to have to change the dates as well. Or the number of dates, kind of thing.
So wait, we have to add 3 days because the sentencing date got moved. We're on the
That's
25th
what
now.
I was about to bring up.
Okay. So the 259 should be 262.
Yes.
Yes. And then that also would correspond to 256 as well, or 257. Yeah.
257. Okay.
We have 262 and 250.
My apologies, I forgot about
I
that.
think we would change the sentencing date. What's wrong
It's okay. At least with somebody remember.
I think defense counsel was about to correct us both on that.
257 or 256?
257.
257.
Oh, because it's 3 days?
Yes.
And 3. Gosh, okay. 257. I'm used to go through the correct one again.
I know.
And then I changed the dates on the recommendation to the 24th, so then that's counting those extra 3 days.
The 25th?
Or I'm sorry, the 25th, yes. It's going back to work.
I know, I hear that.
Okay. I think then I've got them all. Oh, no, I need to then under instant offense change it to today's date as well.
Yes.
Okay, and that's 11 of 12. Okay. Anything else?
Not from the people.
Nothing else to the body of the report from the defense at this time. Thank you.
How about as the guidelines?
Yes, Your Honor. So starting with the prior record variables, this is fixing that what we've already addressed, that being listed as a misdemeanor is actually a felony. It's not gonna change the totals, but PRV 2 should be 5 points and PRV 5 should be 15. As the one goes up, the other goes down.
Yes.
Okay, so it stays exactly the same.
Correct.
And the defense would be in agreement on that because we
Right.
went over it on Monday. Thank you.
Anything
Then-
else?
That's gonna cover, that's gonna be the same on both of those charges. Then for offense variables, the people believe that 10 points is required to be scored for each offense because of the messages that amounted to witness interference. That is,
So what are you asking for?
OB 19 should be 10 points on each file, each count.
For the record, Your Honor, I can appreciate the argument. However, there's been no showing that it stopped Ms. Beauchamp from showing up for court, any interactions. We would object to the 10 points being assessed. I think she's actually even here today, so.
She is here today, but I think that was the nature of the,
It started with don't come, and then it became come and say it didn't happen, and then it became.
I can't hear you.
It started as don't come, then it became come and say it didn't happen, and then it became come and say that you want me to get less time.
yeah, we've made a record of that, and
I would just,
you can place your.
I would just placing the objection on the record for the appellate purpose if it comes to that. Thank you.
And there's been ample evidence. I know we're not having the evidentiary hearing, but there's ample evidence there. So not just in today's record, but overall, it's been in front of me a number of different times, and we've had communications I've had to limit, held in contempt. There's a history here, so I think that's perfect. So then
For
that
the,
changes the OBs to 76.
yes, which raises the level to 4, and the guideline range to 12 to 24. I'm sorry, I'm here jumping the gun. That is assuming there are no defense corrections.
And then sorry, 12 to 24,
Yes,
and that's just on
that's on the felonious assault.
the, okay.
Get to the other ones as it goes.
And sorry,
We can get to the other ones as it goes.
okay, any other corrections on this?
From the defense? No.
Okay, so,
Next, for the assault strangulation, same PRV changes. And then the offense variable rises to 60 total, but the total level remains the same.
okay, so I'm changing that, okay? I've changed the basic information sheet, and then on the final count,
On the final count, I just goes, for the prior record variables, they have 5 scored correctly at 15, but they left off the 5 for PRV2. So PRV2 should be 5 points, not 0.
okay,
And that raises it to 50 and a PRV level of E.
okay,
Then the same change for the offense variables, that being OB19 scored at 10 points, raising that to 60. Total level remains the same, but the minimum range raises to 19 to 38.
okay, so we change that on the basic information sheet. Okay, I have made the corrections. And now we need to look at the recommendations. Recommendation narrative. So that's going to change as well.
And just for clear appellate record, the defense didn't have any other changes for those counts.
No, that is correct. Mr. Pfeiffer, I did not have any others other than my standing objections with regard to OB 19 on the other 2 charges, but the court has ruled on that, so thank you.
Thank you. You do have standing objections.
Pardon me?
You do have standing objections.
Yes, as to the OB 19, but I understand the court's ruling, so thank
Just
you.
wanted to reiterate that I
Sure.
agree with standing
Yes,
objections.
thank you.
Okay, I've corrected the recommendation narrative as well. So, anything else?
Not from the people.
Do we have a victim here who wishes to address the court?
We do, Your Honor.
Thank you. Council, please have a seat. Actually, Council, here's a copy. Would you read through this?
Yes.
What is it?
She wants to change that.
Yes, I can strike something.
And thank you for being here. Please raise your right hand. Do you swear or affirm the testimony you're about to provide the truth, whole truth, and nothing but the truth and nothing but perjury? Yes. You may put your hand down. Please state, spell your name for the record.
My name is Ashlyn, ASHLYN, Bochamp, BEAUCHAMP.
Thank you. I appreciate you being here. I know it's tough. What would you like me to know?
I wanted to read my statement that I typed out. I feel, although our childhood doesn't define us, I truly believe that it shapes us into a person unintentionally, carrying trauma and negative emotions that never had a chance to heal. And although Tyrone is not a saint, I believe he has true purpose and full intentions of being a positive person. I'm writing this statement with a heavy heart and a deep sense of remorse, as I fully understand the seriousness of these proceedings and the role that my actions have played in bringing us to this point. I have already formally acknowledged to the court that I have made false allegations and provided false information, and I have accepted responsibility for my consequences of those actions. I have also made it clear that the father of my children is not a threat to me or my children. There's not a day that goes by that I do not think about the impact this situation has had on everyone involved. I live with tremendous guilt knowing that my actions contribute to circumstances that have placed the father of my children in jeopardy and separated him from his family. I deeply regret allowing my fears, emotions, and perceptions at the time to escalate into something that has caused so much pain. Most importantly, I think about our children. We have 4 children under the age of 4 who need both of their parents. Every day I'm faced with questions, tears, confusion, and the heartbreaking reality that their father is not home with them. I, as a mother, struggle to find the words to explain why he is absent from their lives. Our identical twin boys, who are 4 years old, have recently been diagnosed with autism. As we begin to navigate therapies, appointments, and developmental challenges and the uncertainties that come with this diagnosis, I find myself at a loss for words. The road ahead can feel overwhelming, and there are many moments where I wish their father was here to help carry this responsibility. They need his love, support.
I'm sorry, they need his love and support, you said?
Yes, sorry.
Thank you.
And guidance and advocacy as they learn to navigate this crazy world we're in. As their mother, I do everything I can for them. I know how important it is for them to have both parents actively involved in their life. One of our children has never even had the opportunity to meet their father. He has missed milestones, first everything, and most importantly, memories that can never be recreated. The thought that my children will grow up without knowing the love and the presence of their father because of circumstances I helped create is something that weighs heavily on me every day. His absence has also placed an overwhelming burden on me during one of my most vulnerable periods in my life. After battling and going through postpartum depression while carrying the responsibility of caring and raising our 4 young children, all on my own. The emotional, physical, and financial strain has been immense.
It's been what, immense?
Immense.
Thank you.
There have been days where I have felt completely overwhelmed by the weight of it all, caring for 4 children and 2 who are special need without the support of their father. Has been one of the greatest challenges I have ever faced. Despite the difficulties that brought us here, I know the love he has for his children. I know the comfort they find in him, the bond they share with him, and the role he plays as their father. Watching our children grow without him has been heartbreaking. I see the impact of his absence every day, and I believe our children are paying the highest price for this. Separation. I am writing a statement to avoid responsibility, to not avoid responsibilities for my own actions. I accept responsibility and continue to live with the regret of decisions that can contribute to the situation. If I could take back all this pain and consequences that have resulted from my actions, I would. I can only be honest now and speak from my heart and what this has meant for our family. I respectfully ask the court, may they consider my acknowledgement of wrongdoing, my correction of false allegations I previously made, and the profound impact that the separation has had on our children. They need their father. They need the opportunity to know him, learn from him, be supported by him, and loved by him. As their mother, it's devastating to watch them grow through these critical years without their presence. I understand I cannot change the past, but I hope my honesty, my accountability, and my sincere remorse will be taken into consideration. Above all else, I hope for an outcome that allows our children to have the chance of learning love from their father and giving our family an opportunity to begin healing from the consequences of these mistakes. Thank you for your time, consideration, and understanding.
Ma'am, I find your statement very sad. You didn't do anything wrong. I understand how very difficult it is to be a single mom. I am a single mom. For most of my life, I worked 5 jobs to pay for those kids. I never received child support. I get it. But here's the thing, man, you chose your kids. And that's the most important decision you could make. You also have to choose yourself. And not apologize for being struck. I think you were here trying to make it better so he's not mad at you for what he did. I don't believe that you lied, ma'am, and I'll tell you why. The officer noted Beauchamp's visible injuries, including red marks on her neck, a cut on the inside of her bottom lip, and redness and swelling around her right eye. The officer took photographs. You were seeing black dots. He tried to stop you from exiting. You tried to push past him. He punched you in the face a number of times with closed fists. The evidence shows that, man. You want your children to learn love? We cannot do that if there's violence in the home. What children will learn is that love means getting punched, getting strangled, getting scratched and pushed, and all those things that happened between you and him. Love means pulling a gun out. Love means getting struck in the head with the end of a gun. All those things that happen to you, your children learn the definitions of words by what they see and what they hear, what they feel, and what they have been through. Watching you getting beaten and demoted and demeaned. They equate that with love. That has to change by reporting this, by allowing this to go through, by being here. You're telling them you love them more than anything, and that no one deserves to be hit, punched, threatened, demeaned. I want you to keep your strength and not apologize for things that are not yours. I understand your need to do that. He's the father of your children, and being a good mom, you do not want your children to think poorly of their dad. But man, he's caused them emotional trauma. He's caused you physical and emotional trauma. To the point where you feel guilty about what he did. You feel like you put him behind bars. The only one that put him behind bars is him. I had to hold him in contempt for 93 days because of his behavior. He likes control. He likes the power that he has over people who are not as strong as him. And you are lucky that a relative is raising your children. If you die at his hands, you can't be a mom anymore.
I understand, thank you.
So I understand the protective nature that God gave all women when those children come out of us. As soon as we're impregnated, we are just fierce fighters for those kids, right? And that's what you're doing, and I understand that, but that is not a lie. Loving your children is not a lie. Loving your children is what you are here to do. God gave you those children to love and protect them. We can only protect your children by locking them up and getting them treatment. Otherwise, it's going to happen again and again until someone dies, or maybe you lose an eye or an arm. I have seen all of those cases, man. You don't deserve to take blame that does not belong to you, or to tell this court that this didn't happen, because I know it did, because this isn't just you talking. Law enforcement did a good job of documenting your injuries, man. In the heat of the moment, you told the truth. So while you are saying these things in front of him, so he doesn't get mad at you, I understand this dynamic. And I want to tell you how brave you are and how proud you should be that you are before this court. But please, tell yourself the truth. Get into some therapy. Don't keep choosing the kind of man that shows love with a fist. Any man who is with you should give you roses, not bruises. Should make you dinner, not throw it at you. And should teach your children what real love is. It is kind and patient and tender. It is never with a fist or with a gun. So ma'am, you might want to get into some therapy to learn to love yourself, to know how strong you are, to deal with your children as a single mom, because there's an art to it. I don't know, after all my years of being a single mom, that I've even learned it, because kids are tough. We may be tough on ourselves, but kids are even tougher on us, right? So I understand your frustration coming here and wanting to share that burden with their dad. He's not the one you need to share it with. He can't be a dad and he can't be a significant other or husband. He just cannot be. He needs some significant time behind bars and treatment. Otherwise, he is a danger and you may end up with a dead child. You can watch my court on Zoom. You can come in here and watch it. You can watch any other judge. We see that regularly. Please don't become a statistic in a negative way. I want you to be the statistic that I think you are, one of power and growth and of walking away from violence and putting you and your children on a path of safety. You understand, ma'am?
Yes, thank you.
You need to love yourself. Get rid of all the negative things he told you, because you had a lifetime with him so far, and he told you a lot of bad things about yourself, and you started to believe them, right? Mm-hmm. Yes? Mm-hmm. So are you asking for any restitution? Are there medical co-pays, therapy? He's responsible to pay for any of that.
Am I asking for him to pay for like therapies?
For therapy or anything else that happened as a result of this, that is your right to ask for.
I'm asking that you consider not only, yes, my mental health, and I will be going to therapy and taking it serious and getting on the road to heal and prosper. But I think his mental is very deteriorating as well.
Well, we're gonna get him treatment, but he needs to pay for your treatment, ma'am. I don't know, there's a crime victims fund, there are certain ways you get paid for. I don't know what's in play for you, but any of the co-pays that you're responsible for, he should pay, so I'm gonna order that. What about your kids? How are they doing?
My twins just got diagnosed with ADHD and autism.
So is he paying child support?
He's on child support right now.
Okay, so that will improve, so he'll have to pay his share of all that. Okay, so you'll work friend of the court on that, so he's court ordered to pay. Okay, but how about any other restitution for them? Are they going to counseling or anything else?
Not at this moment. They'll be starting ABA therapy soon.
Okay, but that's not related to this incident.
Right, okay.
Okay, did he destroy clothes, cell phone, windows, anything that you want to be paid for?
No.
Okay. Anything else on you? Thank you for being here. Counsel?
This court is aware of the history in this case of pretty much non-stop communication or attempts to communicate from the defendant to the victim since the arraignment at district court. I have had to present to judges, I think 5 or 6 times, evidence that this defendant has been contacting the victim in violation of this contact order, that he would continue to try and find ways around that. Video visits, calls, messages. He would use other inmate accounts. He would tell her to get new numbers. He would try and use fake names. He recently had her be under the name of Taylor Hollingsworth. Over and over, he denies it until he's ultimately confronted with irrefutable proof. Over and over. At one point, he actually claimed his mental illness made him do this, and then, of course, we realized that was not the case. But especially after Beauchamp's statement, I think there needs to be very important context here. I am going to read one of the letters that he tried to send her from jail. He used a different inmate account, that being James Leggings or Legions. He tried to send it to a
Who happens to be on my docket.
I also caught that. He tried sending it to a fake name, Tammy Lafina, but it was to an address that had belonged to the victim. And of course, he signed in it, Tyrone Howell gave his entire inmate number as well as the entire contact information for the jail. But this is, he also dated it December 29th, 5:20 p.m. He writes, "Dear Queen, hey, how's everything going? I hope okay. Thanks for not letting me know the gender of our starseed, let alone the name, which is very foul. You know I'm really trying to have a very positive outlook on things, especially when it comes to us. I mean, if us is even a thing anymore. I wouldn't know. I can only assume we're still. I can only assume you're still waiting on me, waiting on my return, just letting you know every night I think of you and our starseed. It's very stressful when I haven't heard from you since September 20th, while still confused about what I did. Like, can't you please have some sort of respect for us and all we have and been through, to tell me what I truly did wrong, for you to leave me on stuck, to leave me on silent, to not allow me to hear our starseed's voices, which again is foul. No one deserves to be treated how you doing me. I really thought you had a pure heart. I really thought we and I thought it was forever and always. Like, how do you truly just break our bond that fast? Please don't do me like that. I love you, Queen, and forever. We'll tell the boys how much I love them, and happy birthday to M. I know you about went all out for them."
I know you went all out for them.
Yep. "I love you all dearly, and I wish I was home with you. I pray for us every night. I hope you still want us as bad as I do. You said you could wait 3 years, at least give me in that. Don't allow our starseeds to see you with another. I need you badly, and I pray you still want and need me also. Anyway, to give you an update on these cases, they still try to send me up the road. I need you to please show up to my court date on the 28th of January. Not sure the time, but you can look on 30th Circuit Court page. Find Aquilina and find my name to see the time. but I need your help, please, to win these cases. Please don't allow me to spend years away when you can help me. I just need you to either show up and let them know I'm innocent, or may you write a letter to Aquilina, please. Her address is 313 West Kalamazoo Street, Lansing, Michigan, 48933, Rosemarie, Aquilina. Please, please, I beg of you to offer your help, aid, and assist the father of your kids. Please do it for us, do it for them. Don't take away their dad and allow them to grow up without me when you can help. This is the only thing I beg of you to do. Please, and write back, please. I send you my mailing, not to mention I still send links to your email. I love you, Queen. Please help me and don't forget about me. Yours truly. And then there's another letter he put in here. I miss every part of you. If you're doing this to hurt me, you're winning the roll-up. But I would never, the roll-up, that is what was written. But I would never just leave you in jail not knowing anything pertaining to us. Like, don't you think I want to know our newborn name? Correct? Yes, I do. I apologize for if this seems to run on. There is no punctuation. Don't you think I want to know our newborn name? Correct? Yes, I do. I know you out there living your best life, but please don't forget about me. I cry at least once a week thinking about you and the kids. I cried on their birthdays, knowing I'm not there, and I'm crying now because I'm not there to protect them, nor you, from this cruel world we live in. Queen, please don't let them grow up without a dad like I did. We owe it to them. I owe it to them. We used to talk daily, and I even got more charges added because of doing so. Then now you just cut me off. May you send me a number to call you on. I have nobody in here besides you. I need food. Also, it's like I'm expressing myself to a ghost. Now think of your words in honor that you told me of. Now I'm left with more charges from talking on the phone to you and left from you getting kited 2 times, but I still love you. Please show up to court and send a letter. Please keep trying, and when I'm out, if you truly want to leave me alone, okay. But don't do it this way that you're going. Our starseeds deserve to have me. So please write another letter to the judge and show up to court on my behalf. That's the only way I'm going to beat these cases, is if you show up to court and show out. I hope there's still love between us. Loved always. P.S. Add James Leggings 22539 so we can at least text. I'll send another link. He has been telling her from the beginning of this case, this is her fault. He has been telling her that she needs to come and say what she said today to try and make this all go away. He has been telling her as recently as 5:08 p.m. yesterday, because he continued to call her, calling his friend Dorian Price and having him, or I think it was Pierce, having him do a 3-way call with the victim and telling her it's also her fault for all of the contacts that have happened in violation of the court's orders, instructing her to come to court, make a victim impact statement, and they also to specify about how she needs him out for their children. This man won't stop. His attorney did a fantastic job advocating for him and negotiating with me to give me a plea deal that I did not want to give, which was the 36 months. He then asked for his phone privileges to be reinstated after the umpteenth time of him being caught and confronted in court with violating the orders of this court, as well as that of the lower court. This court agreed, and I agreed, and I believe it was said pretty point blank, you're given rope, don't hang yourself here. He was told over and over by myself, by the court, and by his own attorney, over and over, the only thing that can lose you these 36 months is misconduct in between plea and sentence, which can cover many things, but specifically for you, do not continue to contact the victim. If you violate the no contact order again between plea and sentence, you will lose this 36 months. Don't do it. And then he did it. He did it using other inmate accounts again. He did it having her use a completely new phone number and having her use a completely different person's name. He tried to take numerous steps to evade this in his calls, to evade detection, trying to refuse to refer to her by name. Even at one point saying, this definitely isn't the victim, This is Taylor Hollingsworth, right? Right. Of course, there were many times when they talked about their 4 children together. They named the one child Atlas more than once. And at one point, the victim said to someone not on the line who was just there with her in a store, yes, my name is Beauchamp. It was absolutely her. He knew the consequences. He tried to evade them again. We were here on Monday. I presented all of this. He then denied doing it. Then, on Monday, after that hearing, he continued to message Dorian Price at 9:01 p.m. on Monday, say, WTW, I don't know what that's abbreviation for. Brother, text Whoop and say, I'm gonna give my lawyer her number. She gotta be Taylor. They're trying to give me 5 years. He then did a video visit with him, reiterating, check your messages, check your text, check the text I sent. She needs to talk to my lawyer. She has to be Taylor, the fake name. The person who's, again, the story is still saying Monday, which is it wasn't the victim, it was actually Taylor. And then I said on Monday, I was looking to have the Kilbrews nullified by his actions, and instead of 36 months, I was going to be asking for 5 years. I said on Monday that's my intent was. And then he continued to violate the orders of the court and then try and even use his lawyer, unknowing to her, to commit a fraud upon this court and suborn perjury. And then, even after he said he would admit to the violations, and opposing counsel sent me an email to that effect. Opposing counsel sent me an email to that effect on Thursday and reached out to me again today to continue very effectively advocating for her client, advocating for me to give him mercy and grace. He continued to contact her last night, again, as late as 5:08 p.m. off another inmate account, off another way to try and evade detection. He will not stop. He has been given every opportunity to prove to this court that he will not continue to violate the orders of this court or to commit new felonies. If I wanted to, I could charge him with about 9 different counts of felony witness interference, and now I think potentially conspiracy to suborn perjury.
And stalking.
And potentially stalking. I've done everything I can. I've laid out for him over and over. You are getting caught. You're not getting away with this. Stop doing it. And he won't. And that's without even addressing the underlying facts of this case, which is that he keeps beating the mother of his children. He keeps doing it while on bond. One of the cases that was dismissed didn't involve her. It involved drug possession. He committed that while absconding from probation for his other case, which that probation was terminated afterwards. Being on court supervision in public does not stop them from committing crimes. Being in jail supervision doesn't stop them from committing new crimes. I'm not asking for 5 years anymore. I'm asking you sentence him to the top of the guidelines consecutively across his files. That being 24 months in file 25-5332FH, consecutive with 67 months in file 25-5593FH. Because he chose this over and over. He chose these actions. He chose these consequences, and he tried to rope in the mother of his child. He had the mother of his child in front of this court just admit to what are felonies, that he knows are felonies, lying to officers, because he doesn't care. He needs to be punished appropriately for his actions, not only for the beatings that he put on the mother of his kids, but for the blatant violations and disrespect he is showing to the jail, the court, and to her. He made this choice. Give him what he's asked for.
Counselor, you may approach.
Yeah.
There's no way I disputed whatever you're doing.
No,
Just you.
sorry.
You're fine. Perfect.
All right. May proceed.
Thank you, Your Honor. Well, it's taken us a long time to get to this road, Your Honor, to this point, Your Honor. And I think I am hopeful that Mr. Howell understands, at least as to the court orders, that this time the consequences now of his actions. He did take responsibility this afternoon earlier with regard to not running the evidentiary that we were originally planned on running. And Your Honor, I would ask the court to not consecutively sentence him. I think at this point, he is losing, very likely about to lose any opportunity he had at boot camp, which was something we very much were negotiating regarding, as the court is aware. And given that, I would respectfully ask that we not do as consecutive and not toward the top of the guidelines. I think Mr. Howell is somebody who needs some assistance. He needs some help. And I'm hoping that the Department of Corrections will be able to assist him with that. Thank you.
Sir, what would you like me to know? Remember, you're still under oath.
Yes, Your Honor. I would like you to know that I'm not a troublemaker. I'm not whatever anybody opposed me and thinking that I am. I'm not that. This is just a love story. A person that's in love with his woman and in love with his kids. That's what I'm not. No, I'm not no career criminal. You see my background, and I don't have a substantial. Like I have misdemeanors. I'm not a felon. You know what I'm saying? So that's all I want to know, and I want to say I apologize to the courts for doing what I did do as far as communication.
Sir, this isn't a love story. This is a horror story. If I had to put words to love so you could maybe remember it, LOVE, it would be leave out violence eternally.
Yes, Your Honor.
Love is not found at the end of a barrel or a fist. It is not brutal.
Yes,
It is not violence against the mother of 4 children. It is not to control the other person, but to grow together in harmony.
I'm not into controlling anyone, Your Honor.
I have no evidence of that. I have multiple files here that tell me you're in control of yourself. And you want to stay that way. And you don't want to share control. You don't want to share love. You want to always be the guy in control. And you use your fist. And if you interrupt me one more time, we'll continue this in another 93 days. Because I can. Every word you say will be another 93 days. You're the one that took yourself out of the lives of the mother of your children and your children by your vile actions against them. It is not lost on me, as I said to her, that she came in here claiming fault for all of it. That's your fault. You made her feel like everything was her fault, your imprisonment, you're harming her. Well, you can say no, but I know this pattern very well. I see it regularly, and she should not have thought that it was important in front of you to tell me she lied and she was at fault. She didn't do anything wrong. You did it all wrong, sir. You're not a dad. You're a sperm donor. Fathers do not hit their mothers. Fathers do not choke their mothers. Fathers do not cause violence in the home, which is emotional trauma to your children, even if you didn't lay a hand on them, sir. They know what's going on. They hear the screams, the cries, they see it. You harmed your children as much, maybe more than you even harmed her. And you can say no, but that denial tells me you need a long time away. You don't think you did anything wrong. You did everything wrong.
I'm speaking on.
What would you like me to know, sir?
I'm not what you perceiving me as. You perceiving me as a biased person already. You perceiving me as an evil monster already. I'm not those things, Your Honor.
Already? I have a huge history here, sir. I read already some of the things into the record that happened here. Are you telling me that she didn't have a cracked lip, that there wasn't swelling on her forehead, that you hit her with a cell phone, that she had red marks on her neck, a cut inside her bottom lip, redness and swelling around her right eye, you punched her in the face? You're telling me none of that happened?
It didn't happen, Your Honor.
Well, let me just understand. She just came into the house looking like that. Is that what happened?
I wasn't there, Your Honor. I'm not sure.
Oh, now you were not there. So when police arrived, that was an image of you? That was somebody else impersonating you?
When?
He literally pled guilty.
I understand.
Yeah, I did. I pled guilty to take a plea, yeah, for sure. I did that. But I'm not, what you saying, you saying that like I'm just some angry monster or something. I'm not that angry monster. Then you calling me a sperm donor,
Yeah.
which is very disrespectful. I'm not.
It's not disrespectful, sir. When you assault the mother of your children, you are a sperm donor.
I'm not a sperm donor.
You're a sperm donor, sir. Because fathers do not behave that way. Fathers protect and defend the mother of their children and the children. You did not do that.
Your Honor, you treat me biasly.
Biased how? I have the evidence right here, sir. I have the evidence in your plea and I have the pictures. And we can go to trial, and let me just tell you, you got a whole lot more crimes here and 4 files that you can go to trial on, including the stalking and the interference and all the other charges that could yet be charged that the people have chosen not to file. I'm not going to withdraw this plea because it was a valid plea, because I saw the evidence, because I heard it, because we've had months of you violating court orders. You need to be behind bars.
And I admit that, Your Honor, that I violated.
Stop. You did a lot of things, sir, that violate the law. So I'm going to get on with this, and I suggest you don't speak anymore. And you get in your head that the us and the we thing is not an us and a we anymore. She is free to go on with her life and the life that she now has to be a single mother raising 4 children and deal with the trauma that you inflicted. You needed to respect her and you didn't. You needed to respect your children and you didn't. The minute you don't respect their mother, you do not respect those children. As to count 2, assault with a dangerous weapon, and that is in docket 255332 FH. You are sentenced to 24 months to 48 months with credit for 262 days. As to count 3, assault with intent to do great bodily harm less than murder or by strangulation, you are sentenced to 67 months to 120 months with credit for 257 days. As to count 4, domestic violence and or knowingly assaulting a pregnant individual, 3rd offense, you are sentenced to 38 months to 60 months with credit for the 251 days. Those will run concurrently on this file, however, consecutive to the 255332 FH file.
Your Honor, I believe if he sets consecutively across those, I don't think you get credit on the second case then. So he would still get, if you get the one that he has the most days on, that being the felonious assault, but he would get 0 days credit for the other file.
All right, that's fine. Joe, the two together in the file are consecutive, are concurrent, and they're consecutive to the other file.
Correct.
While he is incarcerated, he will have anger management, domestic violence treatment, and it should be intense mental health treatment, parenting classes. A copy of this transcript will be provided to the victim so she can use it in counseling. He will be responsible to pay any co-pays she is paying as a result of the counseling she needs, or if the children need it, based on the violence in the home and against her. We'll pay $130 crime victims on each file, and then a $68 state cost on each count. So that would be times 3. On each file, he has 42 days to appeal and to request appellate counsel. Please give him 2 of his appellate rights, and then he can choose to appeal or not.
I think we're gonna get that filled out right now based on what he's been telling me here, Your Honor, so I could have a few moments to get that done.
Absolutely fine. I believe that based on the record in total, the many months I've had to deal with him and have watched his behavior, the statements that he's made to the victim, and this whole total case, that he needs this time in the Michigan Department of Corrections for reformation, protection of society, especially his young children and the mother of his children. And this is appropriate to discipline him and deter others, and to protect especially these youngest of victims, and for all women who think they can't come here because they feel pressured, as this defendant has pressured her to can't, and to stand by him despite the violence. This message must be sent. This sentence on these 2 files is proportional to the violence that has occurred and the attitude that I have seen throughout these years. Anything further?
Not on behalf of the people, Your Honor.
Your Honor, there was only 1 copy of the appellate review up here. I didn't have another one. I was looking around, I didn't see one.
Perhaps the one to be made into a copy.
We'll get you another one.
Thank you.
How much did you send me to, Jan?
How much?
Yeah, how many years you just sent me to?
Well, let me go through.
Yes.
24 months, so 2 years to 48 months on one, so that's 2 years. And then the 67 months is 5.5 years on the other.
So that's 7.
That's right.
So you just sent me to 7 years?
That's right. I could do more.
No, Your Honor.
Okay.
I just was asking a question.
Well, I'm just making sure you understand. I could do more. I didn't. I stayed within guidelines that are only recommended.
Okay, I need you.
Thank you, Your Honor.
Here.
Thank you.
And I will have those 2 appellate rights once you're done.
And then counsel, I have that amended order for you.
Oh, thank you, Your Honor.
And for the record, the people looked at the order and approved this.
Quick question, Your Honor.
Yes, sir. What would
Once
you
I
like
get
me to
down
know?
to 3 years or below, would you recommend boot camp?
I will consider whatever is within the realm of the rules and your behavior. I suggest that while you are in there, you learn some honesty and go through your treatment, and then the warden will reach out to me, as they always do.
Yes, Your Honor, thank you.
For the record, my understanding is you're not eligible for boot camp if you're sentenced to more than 3.
Yeah, and that may very well be, but they change the rules all the time, so I'm just making a record. Sir, you need to behave, because here's the thing. If you behave in there like you have here, you're gonna spend your max time. So you might see your children when they're adults. So I suggest you simply behave.
Yes, Your Honor. I was just speaking as when I made it down below 3 years, will I be eligible
Well,
still?
We'll see how everything goes. I don't make any promises ahead of time. That's just not my nature.
Yes, Your Honor.
Then, Your Honor, do I need to hand these two? All right, does the record reflect I am handing them off the forms to Mr. Oh, done, the court clerk, thank you.
Then let me just be very clear. I want to make sure we're still on the record in this. There is no contact with the victim or your children. No contact means no letters, no emails, no Hallmark cards, no messages through third parties. Don't fake another prisoner. The
Still
warden's
can't get
gonna
no
figure it
contact?
out. No contact,
Will not be able to have contact?
no contact. I don't know. I guess somebody can ask me or the warden, but not now. You still tried to contact her or did contact her last night. Sir, you haven't stopped. This is stalking behavior. That's all for the record. Take them away, please.
Deontay William Sims next.
No, I got kids right there. What? Not the right letter.
If not, they'll raise the letter.
Yeah.
Just from the scorn judge.
You see that? Will not affect you.
Oh, had me worried. Had me worried.
I could see that, so I'm telling you, you didn't do all that. Doesn't affect you, sir.
Yes, ma'am.
I'm making sure I see the stress. Don't worry about it. We're used to it in this business, but I feel the stress. I was in practice a long time.
Been on my brushes.
My clients could be wearing diapers by now, so yes, I feel that. Don't worry about it. Okay, breathe. Breathe, okay?
We'll do that next.
All right. This is docket 25-6212 FH, People of the State of Michigan versus Deontay Williams Sims. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people. Good afternoon, Your Honor, and thank you, Jared Austin, appearing on behalf of Mr. William Sims. He stands present and to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you pled guilty to controlled substance delivery, manufacture of a controlled substance known as cocaine less than 50 grams. Punishable by 20 years. Do you recall that?
Yes, ma'am.
Have you taken any medication yesterday or today?
No, yes, ma'am. That's not.
Anything that would interfere in your ability to understand your attorney or the court?
No, ma'am.
Are you supposed to be on medication you're not on?
Excuse me?
Are you supposed to be on medication you're
No,
not
ma'am.
on? Any sign of fever, COVID, or other illness?
No, ma'am.
Thank you. Have you read the pre-sentence investigation report?
Yes, ma'am.
And have spent some time with your attorney?
Yes, ma'am.
On behalf of the people, any corrections, additions, deletions?
Not to the body of the report, Your Honor. Thank you.
Counsel?
I do have some changes to the body of the report, Your Honor. I anticipate they will either be stipulated to or no objection.
All right.
And I'm going to go to the family portion
Okay.
of the report. I'm going to be on page 9.
Oh, 8, 9. Okay.
Yes, Your Honor, there's I guess I will first start with his son, the one who is 18 years old.
Yes.
They have his name wrong. It should be Deontay, his first name, William Sims, just as Mr. William Sims here. So it should be Deontay William Sims Jr.
Okay, I've got that.
And there's one former significant other we need to add that was not included.
Okay.
That would be, how do you pronounce Ms. Bridgman's first name? Well, let me get her first. First one will be Aviance, that's Aviance. Last name Bridgman. She is a former significant other and lives in Alabama.
You know how old she is about? Okay, if you don't.
She like you're so 35.
Oh,
35.
35, okay. Okay,
Then I just have one more, his current significant other, Your Honor, that would be Brianna Walker. I believe that's Brianna with two N's, correct?
Yes, sir.
Brianna Walker. She is 32 and lives in Lansing.
okay.
And right below that section, I'm going to be moving to the employment section, Your Honor.
I'm there.
This was probably true at the time of the report that it was generated, but Mr. William Sims tells me that he has a job, his start date on that will be tomorrow. And I would like to add that if I could.
And what is that?
It is called Kakers Event.
Kakers.
So it's KAIKIERS events.
I'm just striking unemployed and putting this in that box, okay? And the start date is when?
Tomorrow,
So June?
June
Okay.
26th.
Okay,
I think it's unknown what his rate of pay
what's the
will be.
position?
I'm be a mover.
Mover, okay.
It's a table and chair rental company.
I'm sorry, can you say it again?
A table and chair
Okay,
rental
so
company.
you're setting up and putting down the events?
Yes, ma'am.
Okay. Gonna be pretty busy during wedding season.
Yes, especially it's birthdays all year round, so we don't only just do that, like main events. They just did Juneteenth that just passed. I wasn't hired at that time, but
Okay, good.
I'm gonna start tomorrow.
Sounds like a good job.
Yes, ma'am.
Okay,
That would
get your workout.
Yes, ma'am.
that would exhaust the balance of changes
Okay.
that I have, Your Honor.
And I take it the people stipulate?
Sure.
Great. How about the guidelines?
Your Honor, I had one change to the guidelines, that being to OV 15 should be scored 5 points. That's offense involving delivery or possession with intent to deliver marijuana or any other controlled substance. It's a situation of a hand-to-hand buy, so that should be scored at 5 points instead of 0.
Change has been made.
Total OVs other than 10 points. Comes to level 2. Guideline range then becomes 19 to 38. Thank you.
And council, do you agree?
Yes, I do.
Thank you. Let me change that on the basic information sheet. Okay, change has been made. On behalf of the people, what would you like me to know?
Ask the court to follow the agreement. Thank you, Your Honor.
Council?
Thank you, Your Honor. Ultimately, I will be asking the court to follow the agreement as well as the recommendation from the Department of Corrections. Positively speaking, for Mr. William Sims, there's a number of things I'd like to point out to the court. As the report indicates, he was very polite and cooperative with them and engaging during the pre-sentence interview. That mirrors my interactions that I've had with Mr. William Sims while this case has been pending. And as he just stated, we updated the report on, he's working, he's set to start work tomorrow. And I think it's worth noting in the pre-sentence investigation report, he specifically stated that he does better when he's working, when he has that to occupy his time, when he has that stability. And so I think that is going to, add and improve to the stability that he currently has in his life. He's a father. He has 2 very young newborns, as the report indicates. I think it's worth noting his last conviction prior to this offense was 5 years prior. While this case has been pending and Mr. William Sims has been on pretrial release, he has not had any violations of any kind. I think if anything is going to be an indicator as to how well or poorly someone will do on probation, that is it. So I think he's already established that pattern of behavior for himself, and I have no reason to believe that that will do anything other than continue on a term of probation, which is what's being recommended by the probation department. This agreement was reached between the parties, so both sides believe that this is an appropriate agreement. And again, Your Honor, I'm going to ask the court to adopt it and to follow it. and to follow the recommendations and sentence Mr. William Sims to a term of probation, which I believe he will be successful on. Thank you.
Thank you. Sir, what would you like me to know?
I would like to know that I take full accountability for what I did. It wasn't right, you know, and I would do better. And provide for my kids and be better to the community than doing harm.
Well, sir, drugs, you know, you have some young children. Do you want those drugs in their hands?
No, ma'am.
Well, think about that. You gotta be part of the solution, not the problem.
Yes, ma'am.
So I'm gonna put you on probation for 12 months. I can increase that to 36 months or 5 years. I can send you to prison. Hopefully I don't have to do that. You'll not violate the laws of this state or any other. You'll not leave the state without permission of this court. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will not adulterate any tests. You will be randomly tested for drugs and alcohol. If you are positive for anything, then you'll do a secondary test, pay for that. We'll see if it's actually positive or not. If it is positive, I may not send you to jail or prison the first time, but I will definitely send you to treatment, whether it's residential or outpatient, I don't know, but you'll immediately do some significant treatment.
Yes, ma'am.
Were you using or just selling?
Using.
Yeah. So how long have you been clean?
Since this case, honestly.
Okay, so about a year or so?
Yes.
All right.
And I also enrolled myself into CMH outpatient classes while I was out on bond.
Okay, so you'll continue with the CMH program and also complete cognitive behavioral, as well as any substance abuse treatment that they recommend and any aftercare.
Yes, ma'am.
You will attend AA, NA, or CA at least one time per week, and you will have a sponsor within 4 months.
Yes, ma'am.
Sponsor must work the program and have gotten clean that way and have been clean for at least 5 years.
So is PATS one of those classes I go to?
PATS has, yep, you can go to PATS. Yeah, PATS has a really good program, and that would be great.
Yes, ma'am.
But you'll go to AA, NA, or CA one time per week, and then get a sponsor. And they'll talk to you about all of that. The sponsor is really just to make sure that you're somebody you can call if you feel like using, you had a bad day, you call them, you don't use.
Yes, ma'am.
All right. You have a driver's license?
Yes, ma'am.
Very good. You will not engage in any assaultive, abusive, threatening, or intimidating behavior, and you will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who is on probation or parole without permission of the court. As long as everybody's in good standing, then you can have contact, otherwise no. You will contact probation within the next 24 hours or make and keep your first appointment and all subsequent appointments. While you're in this building, council direct him down. It's just easier to make your appointment with them. You'll comply with all written and verbal orders of probation, any court officer or treatment provided, those become orders of this court. And you'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that might violate the conditions of your probation. You will report any arrest, police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours, weekends and holidays are accepted. So if something happens on Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will not give your employer any cause to terminate you. If at any time you are unemployed, you will be part of a work seek program. If you don't get enough hours in this employment, sounds like you will, but if you don't, then you can get a second job and talk to probation about that. You need to work a minimum of 30 hours per week. If you're a full-time student, you will work a minimum of 20 hours per week. You will also work on getting your GED. Did you ever get that?
Actually, I'm in progress with that over on Patton Street.
Good. And just so you know, LCC has the Reconnect program. You can go to college for free.
Yeah, I'm going for digital programming,
Well,
digital creating. Like,
they
that's
have
what
a GED and college program. I don't know, what how full it is or whatever, but there's the Reconnect program. You can go for free.
Yeah, 'cause I'm currently on the wait list for this one. That's why I was waiting on the open up slots, because I can do it online too, so.
Yeah, we'll go over to LCC because there's a program where you can do 2 for 1 too.
Okay.
Okay, all right. You'll serve 365 days jail, credit for 2 days, the balance is held. I can use any wrong with that time, hopefully I don't have to use any. You'll pay restitution in the amount of, it's actually cost recovery. And to Lansing Police Department, and in the amount of $600, and you'll pay crime victims assessment amount of $130, and the state costing amount of $68. I'm waiving probation oversight, fines, costs, attorney fees, and you'll not use any object as a weapon, no guns, ammunition, imitation of a weapon. You have 42 days to appeal and to request appellate counsel. Have I missed anything?
Just the fact that the 600 is restitution, Your Honor. It wasn't money expended during an investigation, so to speak. It was money given to the defendant to buy the drugs that they're out and needs to be returned. So I think it's.
Oh, it's probably under restitution, usually it's cost recovery, but thanks for that.
Yes, that's all I have, Your Honor. Thank you.
Okay, 42 days to appeal and to request appellate counsel. And counsel, you've already agreed to that restitution amount, is that correct?
Yes, Your Honor, we're not disputing that, and I would note that Mr. William Sims is holding his notice of right to appeal in his hand.
Now, if you see that, I'd like to, sir, thank you.
Thank you, Your Honor.
Next, are we done?
Skeeter Kittle, please.
You wish.
2 kids that are like waiting, so, I don't know.
Right back.
What is this one? What do we say?
Skeeter Kittle.
It's, sorry.
It's okay, I also said Skittle earlier. At 2:30.
How many more do we have?
Is it not on the docket anymore?
I mean, should we be ordering?
I don't see it. Please, no.
I also called to adjourn that one.
Yeah.
Oh, I don't have it either.
See, yes, the charge is pending in Eaton County, so we got
Okay,
a new
when
date,
was it
August
adjourned
8th.
to? Because
or
I was
August
not
6th.
told when it was adjourned to.
August 6th, I think it was.
Same final.
What date was it adjourned to?
August 6th at 2 o'clock.
Thank you.
Okay.
All right, then the next one is going to be David Gonzalez.
Oh, I Mr. Puckett, I'm also here for Mr. Puckett.
I know.
Okay.
Okay, so now how many more do we have? I got this.
You're gonna have to-
What do we got now?
We are gonna have to close the courtroom for the next hearing, Your Honor.
Okay, is that our,
For yours?
so how many more do we have?
We've got this plea and then 2 more sentencings, Your Honor.
Oh, my gosh.
Yeah.
Separate up next to your attorney up here. Can I just say ditto? Or I guess which,